lives of the people shall be heard. God save the United States, state and Tennessee, this on the court. On Martin Pittsburgh, presiding, please be seated.
Good morning.
Morning.
Yeah. Is there anything we need to address preliminarily?
Judge, I have redacted the original transcript of Ms. Jacobson's testimony, as well as a redacted version of thumb drive. I believe it's going to be collected in Exhibit 75.
I've got it 73A and B.
73A and B. Oh, correct. And that's what, and the only question is, would Your Honor, for any reason, want us to file the unredacted 2 pages?
Well, I don't see any reason necessary.
That's fine. We'll just have them.
Are we ready to bring out the jury?
Yes, yes.
All right, bring them on in.
Yes, sir.
Jason, Roger wants to use the overhead during
That overhead on this, and that'll project on the big TV. I already had it. Okay.
I'm good. Be seated, please. Good morning, members of the jury. I've heard that we went through some, I don't know, breathing exercises and meditation and all sorts of stuff last night. We have a trainer on the staff now. Good. You're hired, you can say. We'll continue to keep you up here for future juries. And was there any birthday surprises? How did that go? Not as wild as you wanted it to get. But your age didn't get wild. Mine, wild is 9 o'clock. All right, are we ready to go with proceeding closing arguments?
Yes, sir.
All right. Remember, jury, let me make one comment or one observation before closing arguments begin. As I indicated to you previously, what the attorneys say is not evidence. You can take any notes you want on what they say in closing arguments. Just make sure that you clearly mark it as statements of counsel so you don't get confused with the evidence in the case.
Please, court. Members of the jury. I think it goes without saying that your service as jurors on this case is certainly appreciated by the state of Tennessee, I'm sure the defense attorneys, and the citizens of Davidson County. Serving on a jury is really one of the few things that ask citizens to do. Some people live their whole lives here and never get a summons, never get to serve. Others, maybe once, twice, smaller counties, perhaps any number of times. But I suspect that this will be an experience that you will not soon forget, if ever. There are a lot of Waffle Houses around, and I can't imagine that, at least for the foreseeable future, when you drive past one, see one, that this case won't come back into your mind. And I say that because I can only imagine the survivors, the families, anyone connected with this case having to live with that for the rest of their lives. Because of the actions of one man. One man, will submit to you, the state has proven beyond a reasonable doubt, and actually submit beyond any doubt, is the person who committed these acts. But part of your duty is to not just accept that because it has been charged, that relieves the state of its obligation. You heard from many witnesses, about 29 witnesses called by the state to prove the facts of this case, because that is our burden. Well, I'm not going to dwell on that, and actually I do not intend to belabor any of the arguments in this case. And one thing I do want to point out, just because I am putting up a few select portions of the charge does not mean that these are more important than others. I think the judge will tell you you're to take the jury instructions as a whole. No one part is more important than another. But for the purpose of argument, which is what this is, reasonable doubt, the state has the burden of proof. That's the same in every case, be it shoplifting, burglary, first-degree murder, of proving the defendant's guilt beyond a reasonable doubt. And absolute certainty, this is the phrase that I would submit comes into play throughout the course of this case. Absolute certainty is not required, but moral certainty is required. And have we not heard that phrase? Something being immoral, it would be an immoral act to convict someone when the proof is not there. That is sort of a basic tenet, I submit, in our lives and in human behavior. Morality, knowing right from wrong. It would be wrong to convict someone with a lesser standard than what is required by the law. And that is the point we make with that. Hold the state, review the evidence. I submit the state has proven, and quite frankly, even in an opening statement, the defense has told you that they did not contest that Travis Reinking was the person who did this mass murder and but for James Shaw, death count certainly would be higher. Come back to that in a moment. But that's where we are in the sense of the criminal law, I submit to you, is based upon reviewing facts, applying the law as the judge will give it to you, and making that determination of what's right and wrong. And I submit to you, on behalf of the state of Tennessee, it would be wrong not to convict Travis Reinking of all 16 counts in this indictment. His defense is one of that he should be held blameless for his actions. But let's just see what the law is and what he did with respect to the first-degree murder. We did not talk about elements all that much. It's been mentioned many times, but as far as what the state has to prove, and I just put up the first one. Obviously, there are other counts for Torian Sonderland, Keila Da Silva, and Yevgeny Groves. But this is the start. That's why it has Joe Perez. Unlawfully killed the victims. Joe, Torian, Keila. No legal justification, in other words. It's against the law. Intentionally. Every step that this man took was intentional. Every step. This was no accident. This was no mistake. He intended to do exactly what he did. And all along the way, there were choices. And he's the one who made those choices. The 22 or so people who were at that Waffle House had no choice. They were there, some by working, others by happenstance. Joe Perez because of a flat tire. Their choices and Mr. Reinking's choices were so at odds, they did not choose to be his victims. He chose them. That the killing was premeditated. The intent to kill formed before the act. And it doesn't have to be any specific period of time. It could be formed in an instant for that matter. But here we have proof, and you've heard, Mr. Reinking thought about this, thought about doing a similar type of acts a long time before. And even in that time when he's sitting in the truck, that's time. And when he talks about the form premeditation, capable of premeditation, even if he had been excited at the time he fired the shots when he blew Joe Perez's brains out, gunned down Torian Sonderland like he was on some hunting expedition. If he was excited, wouldn't have mattered because he planned to do it ahead of time. He had premeditated ahead of time. But you know from seeing the videos, he was not in a state of excitement. Cold, calculated killer. So has the state proven the elements of a premeditated first-degree murder? I submit yes, beyond any reasonable doubt. Attempted first-degree murder. And again, we've been perhaps so focused or not mentioned enough, perhaps, of what serious bodily injury is. It's the same, the attempt. Did he attempt to kill Gentia Wagner, Sharita Henderson, Kayla Shaw, and James Shaw Jr.? Certainly. His intent was to kill everyone in that place and then move on. But serious bodily injury, you saw the catastrophic battle type injuries, war wounds suffered by Shantia and Sharita. Look at that. Substantial risk of death, yes. Many times you might have one or two of these. Substantial risk of death, extreme physical pain, being shot with an assault rifle with essentially exploding bullets, protracted or obvious disfigurement. They will live with that the rest of their lives. Every morning, they wake up through the day, at night, before going to sleep, if they can sleep. They know they have been disfigured for life. Substantial impairment or function of a bodily member, organ, or mental facilities, absolutely. When you have to learn how to not use your dominant hand and be an artist, I mean, how worse can it be short of death? Those are the counts. And he used a firearm in each and every one. The last four counts are the alternative counts of felony murder. That Joe Perez, Tarian, Sonderland, Aquila da Silva, and D'Ebony Groves were killed during the perpetration of when he was attempting to commit first-degree murder on others. That's essentially it. It does not require, for these counts, necessary premeditation. It's a legal aspect. It's just, did he kill them while he was trying to kill someone else? Yes. And as far as Kayla Shaw and James Shaw, theirs, thankfully for them, do not include a serious bodily injury. Did they suffer bodily injury? Certainly. Certainly. And will they live with it the rest of their lives? Yes. As I submit, perhaps all of us in this courtroom, and many watching remotely. You heard officers and witnesses, people who were there, I submit at times struggling to find the words to describe what they saw when they arrived at the scene and what they saw that Travis Reinking had done. Everything from war zone, horrific, the words that, how do you describe something so horrible, much less live through it? But I submit members of the jury, the one word which ties back to moral certainty and the foundation of criminal law, this was an evil act. Evil. And who described it as that? Man in the blue shirt sitting behind me. He's the one. And what more apt description. He knew it was evil. He committed evil. And that takes us to the defense burden of insanity. And the judge will give you, again, the entire charge, all of the law that can apply to this case for you to consider. But burden of proof. State has a burden of proof, and if you, as a jury of 12, believe that the state has carried its burden, then you determine, is Travis Reinking blameless because he can meet the requirements of the insanity defense in the state of Tennessee? No. Because that law has a high burden. I believe you heard the judge say that it's one of the examples is when the state is taking your child, your under 18 child, away from you, terminating your parental rights, one of the most sacred rights that we have as parents. Travis Reinking terminated the parental rights of the families of Joe Perez, Torian Sonderland, Aquila da Silva, and Ebony Gross. He terminated their parental rights. It is a high standard. For you to find this man blameless, you have to be convinced, clearly convinced, clear and convincing evidence that he had a severe mental disease or defect at the time. And this was at the time of the shooting, at the time when he's driving up there, at the time when he's making that decision. Did he? Haven't disputed that. Yes. Schizophrenia is defined as a severe mental illness. He's been diagnosed with it for some years. Chose not to do anything about it, but you get choices. We have a lot of choices coming into play in this case. But be that as it may, yes. But that's not the end all. That is not the end all to this analysis. That word and, 3 little letters that mean so much, and. That as a result, not just that he had a severe mental illness and killed people, that is no defense, but that as a result, a connection that you and you alone can make. He was not able to understand the nature of what he was doing. The nature. That's one thing, Submit, everyone agrees on. He knew he was killing people. Now he draws them as stick figures a year later. They're people. There's some question about that. He knew. He knew when he put the plan in motion to get the revenge, he was going to kill people, take something from them that could not be brought back, could not be given back, their lives. Or, as So we had an and the first time, this is an or. Because we've ruled out, he knew the nature of what he was doing. He was shooting and killing people. To understand that what he was doing was wrong. The law does not distinguish between legal and moral wrongfulness. It is enough that he knew that it was wrong in some form or another. It's legally wrong to commit murder. It's morally wrong if you do not have a justification. There are other acts that are immoral that are not crimes. Some used to be. Times change. Definitions of mental illness change. But this law is what we go by. And if there is any one thing that says he knew this was morally wrong, it's evil. What he was doing was evil. We stand back, step back, submit, and look at those choices. He says, is this really what he was supposed to be doing? Conflicted, and we can get into all of the psycho testimony about God ordering this, the aliens and things. He has schizophrenia. Apparently he has an active imagination. He has a Taylor Swift attraction. Apparently he must have to stand in line for that, from what doctors say. That's, in and of itself, not that unusual. Maybe the extremes, but again, that has nothing to do, submit, with did he know what he was doing when he killed these 4 innocent people, wounded others, put many lives in danger, in jeopardy. Did he know that was wrong? Did he know that was wrong? Of course he did. He tells you that in his own words. And the judge will give you an instruction about how to go about assessing things that were told to the doctors. And we've mentioned that a little bit about the background and the information. And they say, well, he just didn't know it was wrong. Heard the cross-examination, Cheryl Dowdy of Dr. Wood. It seemed like most every other answer that she had was, well, it can be, it can be. Well, certainly it can be, and in this case it was, that he knew it was wrong. And yes, they are both ordered by the court. The court chooses them and contract to do it. Going to get that instruction about how you weigh expert testimony, how you decide it, and that's, again, your call. Like everything, when you go back to that deliberation room, the 12 of you who decide this case, it's your call. That's the way the system works. You decide the facts. You decide whether the carnage that he inflicted upon these people, the community, was without any legal blame to assess to him. Assessing the expert testimony. It's the thing about dealing with what somebody's thinking. Dr. Deering can show you he's an expert, cite his opinions, and just like really would anybody else. But he can show you things. He can put up, here's an x-ray showing a bullet showing how someone's insides have been exploded by the choice of weapon and ammunition use. He can corroborate that. Same thing with the firearms examination expert, DNA, scientific testing, scientific methods. And that's not to say that there are not methods, testing available in the mental health area. Oh, but if someone refuses to take those tests, you just move on. Base it on your observations, your training, your experience, and your review of the materials that you have. Which brings us to Dr. Eisen. I would posit to you that no one was happier when General Norman stopped questioning her. She was cross-examined. I submit that you saw it, you heard it. Her opinion, I submit, was destroyed by the cross-examination of General Norman. As well it should have been. Even down to the, oh no, I didn't watch the video of what happened outside. Couldn't get it to play. Couldn't get it to play. And then to say, oh well, no, it wouldn't change my opinion. I've made my opinion, and nothing is going to change it in spite of any and all contradictions to the basis. Punishment. And we do circle around a little at odds in its jumping, but what goes through and was going through Travis Reinking's mind was evil. Some other words I believe he used, that he felt it was foreboding, sickening, unholy. It's all wrong. Wrong, 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 and he knew it. But he acted not out of, I submit, some command by God, Morgan Freeman, or, because we know he'd been commanded, according to him, and again, basing this on his telling of the events, that he was mad. He had plans to get this fancy BMW, load it up, sell his truck, go to Colorado, live the good life. Something didn't sound so bad. If your life is really not that great in the first place. And that YouTube video, we've been talking about the toilet seat and all that sort of stuff. If you notice, he had furniture in that. He had, same guitar there. He wasn't living on the street. Wasn't some, person who had to sleep in the truck or under a bridge. No. He had finances, apparently. He had things, computers, to occupy himself and to give voice to his perceived slights and things that he was not having, but felt he was entitled to the extent of taking the BMW. Amazing the advances and the GPS tracking and all of the things. So fortunately, Miss Jacobson did not try to resist any more than she did while she was being carjacked. She was the victim of a crime of violence. But she made a choice, so letting go. She knew he had a tracking device, and they'll get the car back. Almost got it back real quickly, except that he fled from the police, got away, and they back off, as certainly appropriate. They knew as well, we'll find it eventually. They did. Outside his apartment, where he'd taken the decal, the sticker, how much it is, and all of the things you see on new cars. He'd taken that off. Why? Submit. Knowledge of wrongfulness. Could be. Hiding the fact that it's a new car. Without even probably dealer tags on it, but getting ready to go. But they got it back too quickly, and that made him mad. So, enacting some method of revenge. There, its car is taken back. His car is taken away from him. So, what's he say? I'm going to take something from them that they can't get back. Lives. Revenge. Raging against the world is some things people do vocally. Say, I'm being mistreated, the world's against me. It's fine. Not everyone has the perfect life. Not sure anyone does, if you really get down to it. But we have the opportunity for that. We have choices. We have the ability, if we have sufficient intellect and abilities to make choices. There is no question but that Mr. Reinking is an intelligent person. Average, if not above, IQ. A talented person, I submit. A crane operator. Heard Detective Summerall, which, again, a lot of this coincidences, but coincidentally, he had been trained as a crane operator, and your mind can't wander if you're doing that with other people's lives at risk. I submit. Mr. Reinking was able to do that periodically. Get paid for it. Did he have acts on occasion, called into question whether he needed treatment? Yes, certainly. But on this occasion, at the time of the commission of these evil acts, he made the choice, after reflecting upon it and weighing, submit the possibilities. This was no command delusion, no alien delusion, because if it was, he would have not, submit, had any second thoughts. He would not have had any internal discussions about it being evil, sickening. One of the instructions that you will hear is about flight. And it ties into a couple of things. The reason I put it up, it's the law. Flight, voluntary withdrawal of oneself for the purpose of evading arrest or prosecution. What more clear evidence of that was talk of every alphabet agency known to man was in on this event, trying to capture Travis Reinking. He was hiding out, leaving the scene of the difficulty, a subsequent hiding out, evasion, or concealment. He did all that. Literally hundreds of officers, helicopters, and he was able to avoid detection for some 33 hours. That's a long time. Ladies and gentlemen, when you got that much law enforcement bearing down upon you. And on the other hand, an entirely innocent person may take flight, may be explained by proof offered, which is back to the mental health experts. Oh, well, police were after him anyway, he would have already fled. But remember, one of the things he said that when he got back to his apartment, changing, putting on clothes, showering, getting ready, here's the sirens outside. The law is on the way. Time to get out of here, pack my go bag, and see if I can avoid apprehension. Gun, silver bars, the other things, water bottles. And he did for quite some time. And again, in assessing, that's fine, thank you. In assessing all of this evidence of what he did and why he did it, so as to excuse his conduct, says, well, everything can be explained. Oh, he surrendered, followed commands. He did not fight. He did not act like anyone who was in a psychotic episode. Yeah. And I would submit that if you think about it, the procedure he went through in the hospital, if everybody is out, if everybody's CIA, hacking, doing all these things, that would have been the time to, no, you're not going to do that to me. I don't complied. Or when Detective Clare goes to him to say, I need some of your bodily, cells. If you're paranoid, you're going to say, oh, sure, go ahead. I'll swab my cheeks and be compliant. Now, he's just the, how did Dr. Eisen describe him? Polite young man, ready to be released. So choices, and I'm going to not be much longer. I will appreciate that, but these were choices made by a grown man who was living not the best life, but he was living a life of choices. Choice of which Waffle House to go to or to go back. But he made a choice, and several choices, that he tells you that weren't direct commands from God, whatever. Well, God says go shoot people. Well, does he mean, oh, paintball gun? Does he mean camera? Oh, well, I have a number of items I can choose from. Actually, I don't know if you want to cut that off. It's a little. Okay, thank you. What did he choose? His bolt action, small game rifle, the plinking, the 22, holds what, 5 or 6 rounds in its little magazine with the scope. Yeah. Or even the deer rifle, the 30-06 with the scope. Whether you want to characterize it as a sniper rifle, use at a concert or whatever, but yeah, the hunting rifle, the deer rifle, no. The pistol, no. Maybe not that good a shot, but save that for another day. No, he chose a human hunting weapon, semi-automatic assault style rifle, loaded with a magazine, containing 30 of these. 30. Exploding bullets. Human killing bullets. Each one of these, I submit, ladies and gentlemen, could represent another dead human being, but for James Shaw Jr. He saw an opportunity and he took it, while this man was out of ammunition from the first. In that moment where the magazine has to be taken out and he's in his jacket with the 2 other magazines, what choice, what a great choice that James Shaw Jr. made to fight him, to take the rifle away, to be burned. And these went unused. Lives saved. That was a choice. Travis Reinking did not get to continue his carnage of shooting and shooting, not just 3, not just that, for some reason, that sign. He wasn't going to stop until he was stopped. Submit, we all have choices between right and wrong, good or evil, moral or immoral. And I submit the proof in this case is that Travis Reinking committed these crimes, is guilty of these crimes, and he has not in any way, shape, form, or fashion presented any clear and convincing evidence to the contrary, both sides have a burden of proof. You'll hold the state to its, I know. And if you hold the defense to theirs, based upon what you heard from Dr. Wood, Dr. Eisen, and the evidence they presented, this man committed murder. He is guilty as charged. He is not legally blameless for these actions that destroyed so many lives. Thank you.
Good morning. Mr. Moore used the term blameless 4 times by my count. He said that our defense is that we're asking you to hold Mr. Reinking blameless. That's not our defense. Our defense is that we ask you to hold him not guilty by reason of insanity. We have not disputed what he did, not in jury selection, not in opening statement, not in this trial. We never did say that he wasn't responsible for the deaths and the injuries and what happened at Waffle House. Our defense is that he was legally insane at the time and therefore is not guilty by reason of insanity. We live in the state of Tennessee. It's a good and decent state. And in a good and decent state, in this state, the legislature has put in place laws that allow for individuals who are severely mentally ill, and as a result of that, commit acts and without the understanding that the acts that they're committing are wrong. The legislature has put in place a procedure for those people, for these mentally ill people. And that's because people that are this severely mentally ill, that can't understand the wrongfulness of their actions, do not belong in a prison. Now, you were told that you can't consider, if you find him not guilty by reason of insanity, what's going to happen to him. You can't factor that in. But you've also been told, and it's in the jury instructions, that you know he will be detained if you find him not guilty by reason of insanity. He does not walk out of this courtroom. He is automatically detained, and there will be other medical and legal proceedings. So the defense is not hold him blameless. The defense is to find him not guilty by reason of insanity. On April the 22nd of 2018, there's really no dispute that Travis Reinking was suffering from schizophrenia. He was having delusions, hallucinations, disorganized thoughts. He acted on what he believed to be a command from God to go to the Waffle House and shoot 3 people, and that he was doing so in self-defense because of the harassment and stalking and hacking and everything that was happening to him. Now that sounds totally crazy. And that's because it is crazy. But none of us are schizophrenics. We can't possibly understand the suffering that he was going through or understand what was going on in his mind. That's why we brought experts in here to explain it. Now we know that Mr. Reinking has been suffering from schizophrenia for years. How do you know that? Well, we brought in information to you through the experts and the things that they had reviewed. Dr. Eisen talked about how he was having delusions back in 2015 of alien encounters, communicating with aliens, helping aliens fight a war. In May of 2016, Mr. Reinking thought that Taylor Swift had come to his little town of Morton, Illinois, and was there to harass him. And he went out looking for her with his mother, looking for Taylor Swift in Morton, Illinois. He obviously, something was wrong, so the ERS was called and they responded, and then he ended up being hospitalized because of these delusions and this schizophrenia. He was released. Eventually, he goes to Colorado, and in March of 2017, when he's in Colorado, he's having these same delusions, and he reaches out for help to law enforcement by calling 911. And you heard Dr. Wood tell you about that, how he was saying that he's continuing to be stalked by Taylor Swift and stalked on the internet, and that he thinks that the police are actually involved out to get him. You heard there was a reference on the cross-examination of Eisen about in May 17, when Mr. Reinking was writing this journal, referred to as a book, I think is what we refer to. And you heard how he said he was questioning his own sanity and wondering himself, is he crazy with all of these delusions? A month later, in June 2017, my understanding is coming out where he lives and he's going to work, something along those lines, and had a pink robe or pink dress on, talking about whether or not he's a man. And then the same day he goes to the community swimming pool in this same pink robe, pink dress with his underwear on, makes all these statements, jumps in the pool, gets out and exposes himself. This man's not in his right mind. The next month, on July the 7th, he is suffering so bad from this schizophrenia that he says, I've tried to call law enforcement, I've tried to reach out. I'm going to go see the President of the United States and tell him myself I need help. And he sees nothing wrong with going literally to Washington, D.C. to walk on the White House grounds, to try to go into the White House to talk to the President of the United States about helping him. You saw and you heard that roughly the fall, August, September of 2017, that he started making these videos, these YouTube videos. And in these YouTube videos, you heard it described, I think there was 30 of them, that there's over and over and over, he's angry, he's scared, there's all these issues. We played you one of them to get a flavor of what's on there. You could see the madness. He eventually moves to Nashville in roughly February of 2018. Still having these intense delusions, these intense hallucinations, this paranoia. They're out to get him, they're out to hurt him. He believes people, while he's not there, are breaking into his apartment, messing with his computer, taking his passwords, hacking the internet. He's not in the real world, in his mind. Only 5 days before the Waffle House incident, he goes to the BMW dealership. I don't have to walk you through what happened there. But the most interesting, perhaps the most significant part of that whole incident is when the salesperson said, I was with him for about 5 minutes outside the car, with him about 8 or 9 minutes. And after he took the car, I went inside, and the other people inside said, was he on drugs? Was he on alcohol? And it hit her. She remembered, I've had a friend suffering from schizophrenia for 7 years. And the interaction she had with Mr. Reinking, her words were, it did seem to parallel. She's noticing it 5 days beforehand. The police do this pursuit for 2 minutes, 1.5 miles, 40 to 50 miles per hour, and they pull off of him. And as you heard, that made him wonder what's going on. The police knew I took the car, they were right behind me. What is going on? That added to his schizophrenic issues. You saw his apartment. You can see pictures of this apartment where this man lived at this particular time. He had a folding chair, a computer desk chair, a bunch of computers, phones, things like that, sleeping on the floor, not a couch, nothing. He, I would say, is at the height of his schizophrenic delusions, hallucinations, disorganized thoughts, paranoia. And then he believes, he wakes up in the morning, I think he said, and he said he asked for guidance, and then he believes that God tells him to go to the Waffle House, wear only a green jacket, take your gun with you, and kill 3 people. The people at the Waffle House are with the CIA and the FBI, and they're out to get him, and he must act in self-defense. He said that if, in effect, I'm going to do what I believe God is telling me to do, but if I'm mistaken in what God is telling me to do, God will make the Waffle House be closed, make nobody be there, make my gun jam. He's in turmoil, but he believes that God has told him, you need to go there and do this as an act in self-defense because of all the torment and the harassment that you are receiving. Again, to us, it's totally crazy, but to him, it's reality. They talked about choices. And my co-counsel in the opening statement talked about choices are based on your perception. How do you perceive things? Well, when you're a schizophrenic and you're in Travis's world, you don't perceive things like normal people do. Mr. Reinking gets into his truck, his own truck, registered to him, that has paperwork in it identifying him, where he lives, and he drives to the Waffle House. He does park in the front. There's no question about that. Now, the state would have you believe that, well, he parks right in the front where he can see everything going on in the Waffle House. I disagree with that. Show you this picture just real quick. I'm not saying that you can't see in part of the Waffle House from where he parks, but the state trying to sell you that he parked right in the front where he could see everything going on in the Waffle House is simply not accurate. You can just look at the picture and tell that. He sits right there. You can pull the picture. He sits right there, and he sits in the car, and he's waiting on a sign. And while he is sitting there with nothing on but this jacket, Mr. McMurray and Mr. Shaw walked by. And if you remember, Mr. McMurray looked at him, and he said that he had a piercing stare. Mr. Reinking, didn't seem right. He looks like the person who would shoot up a place. James Shaw came in and said, well, what Mr. McMurray really said was, look at that crazy MFer. James Shaw said he looked like he didn't care. James Shaw testified, and this was very interesting, he had that same look on his face as he does today. And I would imagine y'all have been looking at Mr. Reinking this entire week, at least at some points in time. Mr. Reinking is sitting there and he says, I'm looking for a sign. I'm looking for a sign. The blinking hazard lights come on, and he says, those are taunting me. But then he sees the sign. Mr. Perez walks by with a hat on, and that hat has a number 3 on it. This picture is the picture the first picture that I gave to Dr. Deering to show all the clothing that was taken, and he described a black hat and a blue hat polo. They both had number 3s on it. I blew up one of them so that you can see it better, where you can clearly see the number 3. And if you recall, there was testimony that Mr. Reinking was obsessed with the number 3. He sent 333 starbursts to Taylor Swift. He talks about the Holy Trinity. He talks about him and his 2 wives, although he doesn't even have one. He would talk about the 3 of us, I think with Dr. Eisen, meaning me, Celine, and Crystal. But sometimes the 3 of them were me, Celine, and Crystal through Dr. Eisen. He believes he's given the sign, and he gets out, and we all watched what he did. Now, one thing I want to bring up that I thought was interesting that the state brought up on cross-examination was with Miss Eisen, and we've heard about cross-examination of Miss Eisen. Miss Eisen, isn't it something to the effect about Mr. Reinking wearing a disguise? A disguise is what she was trying to sell. That he disguised himself by being naked. I would say that could be the worst disguise that anybody could ever have. Maybe you could have put on jeans, a shirt, a jacket, or something. And if an APB goes out saying there's a guy in jeans and a shirt and a jacket or a hat or whatever, you might blend in with some other people. But when the APB goes out and it says there's a naked man running down the street, that's not a very good disguise. But the state would try to couch that and sell you that look at this choice of his disguise. He leaves the scene, and at first in the description was he ran away. And that's why we asked questions to several people about, did he run away or did he walk away? And there was several of them that said he walked away. James Shaw, trotted away or fast-paced walk. James Shaw said, saw him walking down the shoulder of the road. Kayla Shaw, walking on the shoulder of the road without any clothes on Murfreesboro Road. Chelsea Owens, in the grass area not too far off the road. Officer Gilpin with his K9 Brax tracked a scent, if you remember, in the grass right next to the road. So Mr. Reinking, in this fleeing, walks almost a mile naked down the side of Murfreesboro Pike. If you recall, Mr. Reinking had driven his own vehicle to the scene, and we had, on cross-examination of Ms. Connor, we pointed out that the keys were in the ignition. And she herself said, we were wondering, why didn't he leave in his own vehicle? That's a great question. Why didn't he leave in his own vehicle? Because he's out of his mind. He leaves the vehicle there with all identifying information of who he is. He leaves the scene, and you heard the testimony that he was afraid that the police would come. He's already got this paranoia of them, and that they would come for him. And he has this paranoia of the police and the government, and so he flees. He goes and gets this thing, and he puts this backpack together, and he's caught. And you heard about the backpack. I'm gonna come back around to that backpack, but I want to address two other issues real quick before the backpack. I thought it was interesting that Detective Summerall said this was the easiest homicide ever to solve. Gun, video, Travis Reinking's truck on the scene. Of course it was. It's committed by a person with a severe mental illness. Of course it would be easy to solve. Another issue before we move on that I want to address, because it comes up kind of chronologically here, is when Mr. Shaw took the stand and he was testifying, and he said that when he went outside that he heard Mr. Reinking make this racial statement. I don't know why he said that, but we put on proof through the detective Clara that when they interviewed Mr. Shaw 3 days after the incident, Mr. Shaw himself said twice, I never heard him say anything racial. Not once, but twice. Told the law enforcement, I never heard him say anything racial. But when he testified, all of a sudden we have that statement. So I just want you to keep that in mind. Keep that in mind. So we get back to the backpack. Now this backpack, the idea, if you believe what the state is saying, and that Mr. Reinking was going to take this backpack and somehow he was going to make his way to Canada. In the backpack, there's water, silver bars. Silver bars. There's a gun, but did you hear what the ballistics experts say? It's not in normal operating condition. And there's a Bible in the backpack. And that would make total sense from a man who thinks he's being commanded by God to do things. He'd have a tough time going to Canada without his passport that was left in the safe when you saw it was opened up in front of you. I think there was actually more than one. So is that really what was going on here? This plan to go to Canada? And the safe. Now that was interesting. Detective Summerall, the lead guy in this whole thing, took the stand and he said, yeah, I looked in the safe in Mr. Reinking's apartment and I found the BMW key. It was in the safe. The state introduced the safe. So then we asked him to come out here. Was there anything else in the safe? No, not that I can remember. I don't remember anything else being in the safe. No, I don't know if there's anything else in the safe. Don't remember anything in there. That BMW key. Okay, well, let's look. So what's in the safe that was found inside Mr. Reinking's apartment? A letter to Oprah Winfrey asking for help with his situation with Taylor Swift. A letter to Taylor Swift. There's other letters. You can read them. They're in evidence at this point. But to Summerall, apparently that wasn't significant in this case. That's not important in a case dealing with insanity. Just that BMW key is. But he had those in his apartment when they searched it. Let's talk about motive briefly. The motive is not, you heard early on, state likes to say, oh, motive's not, we don't have to prove motive, and they don't. But it's on some level, you have to look at a case and say, what could possibly be the motive for doing this? the state has pitched to you, even today, the motive was that he had stolen this BMW and somebody had taken that BMW, and out of revenge, he went to the Waffle House and did what he did. Really? He was so angry that they took that BMW that he went to the Waffle House with that gun with nothing but a jacket on and shot all those people? That's the motive? Or was, in his mind, was he commanded by God to do those specific things? Now the experts. So, should be pretty clear by now that before we even came on this case, the court ordered these experts to evaluate Mr. Reinking. That is the procedure we have in Davidson County. Now, defense attorneys can go out and hire somebody to do that, but there is a mechanism in place that for the courts to send people to Vanderbilt and eventually the Middle Tennessee Mental Health Institute, if necessary, for them to be evaluated. And that's done so that independent evaluations can be done. Not bought and paid for by the state, not bought and paid for by the defense, an independent evaluation. So he first goes to Vanderbilt University, and the case is assigned to Dr. Wood. Dr. Wood is one of 7 people in this entire state that's board certified in forensic pathology. She has done, she said, I believe it was nearly 900 of these evaluations. And what she does is she says, I gather records, I gather reports, I get any information I can get, videos, whatever else, from the state and from the defense. And I conduct interviews and I meet with colleagues and I do my evaluation and I come back with my opinion. And in this case, her opinion is that at the time of the offense, Mr. Reinking suffered from a severe mental disease or defect, that being schizophrenia, and that he could not appreciate the wrongfulness of his actions. We had Dr. Eisen. Dr. Eisen, again, it's the same thing. Once Mr. Reinking is finished at Vanderbilt, he was sent for inpatient evaluation over a period of roughly 30 days or so, and then I think it continued after that, with the team at the Middle Tennessee Mental Health Institute. And they do the same type of thing, reviewing things, reviewing records, reviewing reports, and then they, with a collaborative effort, come up with an opinion and a report. And MTMHI came up specifically, Dr. Eisen, Dr. Kovach, who you heard had been there for over 20 years, and Dr. Fikes, all collaborated, adopted, and signed off on the report, with the opinion being that Mr. Reinking suffered from a severe disease or mental defect, that being schizophrenia, and that he could not appreciate the wrongfulness of his actions. 3 doctors from MTMHI signed off on that opinion. 3 doctors. You heard about how the interactions with Mr. Reinking there, that he was continuing to suffer some delusions while he was being treated in MTMHI. You heard about hallucinations. He thought that the government was trying to kill him. The question was asked, with these delusions and hallucinations and disorganized thoughts, do schizophrenics believe them wholeheartedly? And she said yes. And I think the question was asked, even if there's proof to the contrary shown to them, they still believe it in their mind. She said while he was at MKHI, he would talk out loud and have conferences with aliens. Heard voices of aliens, thought he was married to a supernatural being. He said any logical person would see that what I did was self-defense. Mr. Moore mentioned something about cross-examinations, and specifically cross-examinations of Dr. Eisen. And I want to briefly talk about some of the things on these cross-examinations that I thought was somewhat peculiar. If you recall, when Dr. Wood was cross-examined by Mr. Dowdy, there came a point in time where this handwritten journal was brought out, and they were going through certain parts of it. And they got to page 13, and they read what was on page 13, and Mr. Dowdy said, there's nothing in there about a command from God. You don't see anything there about a command from God. Where's that? You don't see anything about that. And then he moved on. But I was paying attention. So when I got up, my redirect, I asked her to turn one more page to page 14. And there's the whole command from God, the whole thing. She read it out to you. He's had the journal. We all have the journal. We've all read the journal. But he asked her a question, where is that? She doesn't know off the top of her head, and then he moves on, knowing it's on the very next page. He asked her about exhibitionism and sadomasochism, and I don't know if you caught it, but he said, as far as exhibitionism is, well, he took his own pants off before he left the house. And he went to the Waffle House and harmed people. Is he trying to say that this was some sort of sexual thing with exhibitionism and sadomasochism? Miss Norman cross-examined Dr. Eisen. And there came a point in time when she said, Dr. Eisen, look on this page at this line. What did Mr. Reinking say to you? And you heard the racial slur, the racial statement. And you could hear an audible gasp in this courtroom. Clearly giving the impression that it was Mr. Reinking that statement originated from. Clearly giving that impression. But again, Mr. Evans, on his toes, paying attention, knowing the facts, got up on cross-examination and said, Dr. Eisen, read the rest of that line. What does that say? Mr. Reinking was telling me what somebody else had said at the Waffle House. Now, had we not been on our toes paying attention, you would have been left with the impression that that's what he said at the time of the killing. We had to come forward and give you the context. It was brought up. Miss Eisen, at some point, Mr. Reinking showed a fondness for you. He was into you, he liked you, whatever the word was, a fondness with you. The fondness was, according to her, is, yeah, he thought that his wife was inside her body, that he was talking to his wife. But if you were left with just this fondness, you would have this picture, something funny was maybe going on. But this fondness was an active delusion. At one point in time, there was cross-examination about Miss Eisen. You didn't put this in your report, did you? Where is it in your report? You didn't put this in your report. And what she was talking about was actually in the earlier report. Ms. Eisen had put certain things in her reports. But Ms. Norman was trying to cross-examine her like, you didn't put it in your report. You didn't put it in your report. And speaking of reports, she was cross-examined about this wasn't in the report, this wasn't in the report, this wasn't in the report. Those reports are summaries. They're not transcripts. They also thought that initially, and we have to clean this up when we get back up, oh, he refused to take the test. So you couldn't give him the malingering test because he refused to take it. Leaving the impression that somehow Mr. Reinking knew what was coming and said, oh, I'm not taking the malingering test. But we have to get back up and clear this stuff up. But he didn't know what the test was, had no idea. He was just refusing to take the test. So I bring all that up because it's significant. When we're trying to bring to you the facts of this case and the whole picture, and when some of these cross-examinations are bringing to you a misperception, that is significant in this case. This is serious, very serious. And to do things in a manner that don't give you the whole picture or the complete context is not right. The state called 7 what were supposed to be rebuttal witnesses. Now, rebuttal is basically we put on our case, and then they're supposed to get up and put on proof that would contradict our case. That's what rebuttal proof is supposed to be. So they put on the BMW people, the 2 officers, and the salesperson deposition, which we didn't really dispute any of that, but I still thought it was interesting because you got to hear the salesperson say, yeah, he appeared to be schizophrenic. He appeared to be acting as just like my friend when my friend has a break. Then we had Summerall, who was pretty much off the stand as quickly as he was on it. And then we had the silver bar guy come in. And the silver bar guy just said, yeah, he bought some silver bars from me. Wasn't very complicated or long. He was polite and shy, and he came back and picked them up. I have no idea what that rebuts. Then we had the 2 officers who brought in the styrofoam drawings. You've seen them. They're in evidence. And the second one has a spaceship, a flying saucer on it. This is a year later. Almost a year later, has a flying saucer with 3 aliens in it. I would submit that supports my case. Doesn't rebut my case. So you saw 7 people. But who did you not see? You didn't see an expert come in here and dispute Dr. Wood or Dr. Eisen. We've had almost 4 years this case has been pending. Almost 4 years. You know what the state has potentially as resources. Did they go and talk to somebody or not? I have no idea. But over a 4-year period, when we get to the end here, I'll tell you what didn't happen. Not a single forensic psychologist got up there and said Dr. Wood was wrong or Dr. Eisen was wrong. That was not in the rebuttal. I think you know why. Our burden was to present to you by clear and convincing evidence that Mr. Reinking suffered from a severe mental disease or defect, and that as a result of that, or because of that, he did not understand that what he was doing was wrong. And we have met that burden. We've met that burden starting back in 2015, 16, 17 with the schizophrenia. They really don't dispute that part of it at all. And we've met the burden by showing that Mr. Reinking was in a crazy state of mind at the time that this happened, believing delusions and hallucinations and disorganized thoughts. Again, it's hard to understand. I don't know that anybody can understand it unless you are him. But that's what happened in this case. You know, we have to show as a result of, did the schizophrenia result in this actions that he didn't know were wrong. Well, what else would have caused it? There is nothing else that would have caused it. The schizophrenia resulted in his actions, and he did not understand and appreciate the wrongfulness of his actions. I want to say just a couple more things before I close. First, I want to talk about sympathy. There's not a person in this room that doesn't have sympathy for Mr. Perez and his family, Mr. Sanderlin and his family, Aquila De Silva and family, to Ebony Groves and the family, for Miss Wagner, Miss Henderson, and everybody else that was in the Waffle House. These victims and their families suffered and are continuing to suffer. Monday and first thing Tuesday morning were two of the toughest days in my career to listen to that. You can have sympathy. We all sympathize. But in making your decision, the judge is going to tell you, you can have no prejudice or sympathy or allow anything but the law and the evidence to influence your verdict. So you can have sympathy, we all do, but you can't come up with a verdict based on that. That's our law. When you go back to deliberate, you talk to each other, but the 12 of you that will remain on the jury, you each have the right to make your own decision in what you think is the right decision in this case. You have to respect the opinions of the others, but you each have your own right to make your own decision, whatever that is. At the beginning, when we did the jury selection, I asked each of you, if we carry our burden of proving by clear and convincing evidence that Mr. Reinking suffered from a severe mental disease or defect, that being schizophrenia, and that as a result of that, he could not appreciate the wrongfulness of his actions, would any of you hesitate to check that box that says not guilty by reason of insanity? And every one of you said, no, we wouldn't hesitate in doing that. If you meet your burden, we'll check not guilty by reason of insanity. Well, ladies and gentlemen, we've met our burden. We've brought you the proof. Now we're asking you to find him not guilty by reason of insanity. Thank you.
All right, Mr. Jury, we're going to take our good morning recess at this point in time. Please keep in mind the trial is still in progress, so do not discuss anything about the trial or share your thoughts at this point. We'll get back here in about 10-15 minutes. All right, bring him on in.
Thanks, Joe.
Be seated, please.
Ladies and gentlemen of this jury, I'm not gonna do like defense, wait an hour, 15 minutes to mention the victims of this horrible, horrific massacre: Joe Perez Jr., Torian Sonderman, Aquila De Silva, DeEbony Groves, Sharita Henderson, Shantia Wagner, Kayla Shaw, a name that defense left off curiously, James Shaw Jr. That's what this case is about. It's not about Travis Reinking, no matter how much they want to spend time talking about his thoughts, his feelings. It's about what he did to them, the lives that he took from them. These are people who loved and were loved back. This is a man who wished he had that. Instead, he went to that Waffle House. This time, he said, I would punish them by taking something they couldn't take back, some of their lives. Those are his words. Those are the words of a murderer, a man who would kill 4 innocent people, a man who will walk into a restaurant full of people who are just trying to enjoy life, who come there from various different locations, meeting by happen chance. That's what he did. Travis Reinking committed 4 acts of murder, 4 acts of attempted first-degree murder. This isn't about what he feels about it. It's about what he did. You've seen the video of him arriving at the Waffle House, and what you will see when you get it in evidence, when you get the chance, is that he sits there and he waits. He's not waiting for a sign. He's waiting to give himself the courage. You've heard him describe his feelings in that moment. He's trying to talk himself into it. You've heard the testimony. This is a man who you've heard wrote about wanting to commit mass murder in the past. You heard the testimony of Dr. Eisen. She read his journals. He's at a Nelly concert wanting to pull out a 30-06 rifle and be a sniper, shooting people, innocent people trying to enjoy a concert. As he sat there in that truck for those minutes, as Joe Perez is going back to his car to check on it, as DeEbony and Sharita are walking into the Waffle House, as Aquila and Shantia and Abede and Alexis are sitting there waiting on their food, as Kayla's sitting in the car with her girlfriends, her cousins, after a night out, waiting on their food, as James Shaw Jr. and his friend Brennan, his best friend, are walking in, laughing, talking about how high the plates are being stacked. What he's thinking, what this evidence in this case has shown to you, he's thinking about wanting to carry out an act that he has wrote about, thought about, and is now on the verge of doing, and he's torn. He's conflicted because he knows it's evil. He knows it's unholy. He knows it's unclean. He knows that he will feel wrong when he does it. These are the words that he described about it after the fact. He knows that. He just wants the courage. This is a man with no courage, though, because he can't even come in here and tell you that he will accept responsibility. No sympathy has he given to these families. No remorse. None. This is a man who April 22nd, 2018 took so much. He took so much from them. He robbed Joe Perez Sr. of ever meeting Joe Perez III. Robbed the Groves family of ever hearing the Ebony sing Jesus Loves Me ever again, the last time she sang it, as she sat there in that booth at the Waffle House. Robbed Abede of being able to truly enjoy the celebration of the music video that he had just made with his little brother that same day. Robbed Torian Sutherland of ever achieving his dream of being a chef or cooking Thanksgiving dinner ever again with his aunt and the rest of his family. This is a man who took so much, and yet he sits here today and asks of you not to take his liberty. His attorney says this is a man who doesn't deserve prison. This is a man who deserves to be found guilty. Guilty. 16 times when you get to the verdict form, you should be saying guilty. Nothing else. You've seen the evidence. You've heard the testimony. You've heard the witnesses come in here. We spent one day talking about the victims and what he did. The rest of the time we've been spending talking about him. And that's unfair. It's not right. It's as wrong as Travis Reinking knew he was on that day. He knew he was wrong. He knew what he was doing. Mental illness is not an excuse. That's not just me saying it. That's not just General Moore saying it. That is what the judge is going to instruct you on. It alone is not an excuse. So what if he has a mental illness? That isn't enough. Travis Reinking isn't the only person that's got problems, struggles, issues that he's got to overcome. He ain't the only person who's got something difficult to deal with, that thinks he's been dealt a bad deal. So what? This man knew right from wrong. This is a 29-year-old man who worked a job as a crane worker, had thousands of dollars at his disposal to go and buy silver bars so he can flee. He had his own truck. You heard him talking about how he wants to paint it and do all these things to it. His own apartment. It doesn't matter that he had a mental illness. That's not enough. That's not what the law says. The law says defense, and the defense alone had to prove to you by clear and convincing evidence that on that day, when he walked into that Waffle House, when he stepped out of his truck and pulled that assault rifle and pointed it at Joe Perez Jr., who was just trying to walk into the Waffle House, and shot him, and shot him, and shot him, and then saw Torian running, and shot him as he ran for his life, saying, I'm not going to shoot him in the head yet because I want him to have a little time to get right with God and maybe feel as bad as I had, and continued to shoot him, and came back to Joe, whose body lay there on the ground, shot him again. That's malice. That's somebody who knows what they're doing. Just a malicious person, vicious person, evil person. There's no way he didn't know that what he was doing was wrong. He knew it. You heard testimony from doctors. 2 of them. They came in. They gave their statements. And one thing that was very clear is that they didn't give this case the respect that it was due. When you took an oath as jurors in this case, you took a solemn oath to pay close attention to all of the facts and evidence in this case. Pay close attention. That's not what these doctors did. They overlooked things that they had access to. They ignored certain things. They picked certain things that they wanted to pick and choose instead of picking everything. Dr. Wood told you that she only met with Travis Reinking one time and discussed the incident. One time. And yet she comes to you and tells you that she can come to a conclusion about his actions on that day. She spoke to him once. The next time that she wanted to speak to him, she wanted to give him a malingering test. A test to determine whether or not he was faking having mental illness or perhaps exaggerating that he had mental illness. And what did he do? He said, I'm not taking that test. It's okay. Travis Reinking special. Yes. She told you when she looked at the reports, the medical records that helped form the basis of her opinion, that what she saw was a prior time that he'd gone to a hospital. And if you remember, if you listen closely, one of the things that he did then was say, I don't want to participate in this. It's a man who makes choices. He doesn't want to do things that he doesn't want to do. He refused a malingering test with Dr. Wood. Then he goes to see Dr. Eisen. Dr. Eisen gives him one test. Of course, he likes her. She's friendly with him. It's a man with no girlfriend, no friends at all. And here you have this woman who's coming to sit down with him every day, twice a week. Sit with him for an hour and a half and talk through his feelings. And he's starting to have affection for her. He starts to find her attractive. He's calling her beautiful. No big deal to her. It was a big deal to him, having this person who comes and sits down with him, a man with no friends. Now he's got somebody who's paying all the attention in the world to him. So he agrees to a test. But once he takes the first one, once he knows what the test is, never takes another one. Never. And so now you have two doctors who've come to you and testified with certainty that this man has not exaggerated in any way his symptoms, and yet they only administered one test to him. Well, Dr. Eisen, why did you want to keep administering tests? General Norman asked, if you didn't think it was necessary. Well, of course she thought it was necessary. She just let him make his own decisions. That's what they have done in this case. They decided to pick and choose amongst what words they wanted to believe of his. You heard his testimony, their testimony, Dr. Wood, in which we went through a long list of things that would be an indicator of wrongfulness. Fleeing from the police. It can be. Hiding out. It can be. Trying to disguise yourself. It can be. Describing your actions as evil. It can be. This is the testimony not of an unbiased person, but of an advocate. When she took that stand in this trial, she decided to become his advocate and not an unbiased witness. Perhaps in her other cases, she has not been so conflicted. But in this one, for whatever reason, it's clear from the evidence and the testimony that she was. Dr. Eisen, same questions. if you describe your actions as evil, are they an indicator of wrongfulness? Now, you, ladies and gentlemen of this jury, know that evil is as wrong as can be. And that's how he described his actions. And of course, Dr. Eisen reluctantly agrees that if you describe your actions as evil, then indeed you do understand that what you have done is wrong. But it was reluctant. Why is that? Perhaps she refuses to back down from the mistakes that she made in her evaluation, overlooking certain aspects of the reports that were given to her. Defense told you that three doctors at MTMHI signed off on her opinion. You only heard from one. I didn't see Dr. Fikes walk in that door and testify and be subjected to cross-examination, or at the very least verify that that was his opinion. In fact, to the contrary, what you heard the testimony was that Dr. Fikes worked out of a different location. There was no testimony that he actually met with Travis Reinking. That's not a supported opinion. Dr. Kovacs could have easily come in this courtroom for defense if they thought he was going to provide them with valuable testimony. Where was he? The only evidence that you heard about Dr. Kovacs is that when he was conducting the evaluation with Travis Reinking, he grew increasingly concerned that Travis Reinking had not committed this crime because he had been commanded by God for revenge, and therefore, at the time, was certain that he could support the opinion that Dr. Eisen ultimately came to. So it's not three doctors. It's one doctor from MTMHI, Dr. Eisen. Dr. Eisen, who couldn't even tell you which reports and journals she reviewed. Dr. Eisen, who couldn't even tell you, she didn't even look at the video. Now, that was just yesterday, so I know you know how the state feels about that. But I want you to understand, how is it that you can give your expert opinion about someone's actions if you haven't even looked at the actions? When we asked them, well, you're an expert witness. You sit in this courtroom. You could have watched the trial. They didn't even have to come to the courthouse. There's a camera right there. They could have cut it on while they were in their office doing their own business and listened to the testimony. They didn't even care enough to do that. Didn't even care enough to hear the testimony of the eyewitnesses. Uninterested in that. And yet, they have an expert opinion based on limited conversations with Travis Reinking, based on him saying that he had been commanded by God. Or was it self-defense? Or had he been baited by the FBI and the CIA into tricking him? Or was it the aliens? You know, there was also the thing where he's fighting in some war with the aliens. It can't be all of them. They're trying to say it's every single one of them. If you're acting out of self-defense, you don't need a command from God. James Shaw Jr. didn't tell you that he needed God to tell him to fight back. He told you that he saw Travis Reinking coming through that door, and at that moment, it was his time to fight back because it was going to be his life or Travis Reinking. So he had to move him out the way. He didn't need a command from God. Travis Reinking didn't need a command from God. My question to you is, how is it that a man who has planned to commit an act, planned to kill people, tell you that the only reason he did so is because he was commanded? How How is it that a man who has spent so much time writing and thinking about mass murder can tell you that the only reason that he committed a mass murder is because he was commanded to? God didn't have nothing to do with that. That was Travis Reinking, every single bit of it. God didn't tell him to take a Bushmaster XM15 assault rifle. He had 4 guns, 4 of them. He could have picked any one. Every single one of them guns would have killed people, but he didn't pick the other guns. He picked the gun that could inflict the most damage. He picked the gun that could shoot the most rapidly. He picked the gun that would shoot with high velocity and cause the bullets to act like they were exploding, leaving Sharita and Shantia with injuries consistent with having been in a military battle. But really, they were just at a Waffle House. He made those choices when he picked that gun. Defense says to you, well, he was naked, and a naked man can't disguise himself. You heard the testimony of the eyewitnesses. Kayla Shaw cowering in between the stools and the counter. What did she say to you? She looked up and all she could see was his naked private area. That's the thing that stole her attention. She never got to his face. James Shaw didn't say, I can identify Travis Reinking. He got in a fight with the man. What was the testimony? He gave a description: white man, blonde hair, naked. Not his face, because the nakedness distracts. Now, every plan, every criminal is not the world-class criminal you see in a movie that is doing a heist and never gets caught. Even some of the smartest people in America get caught. They run Fortune 500 companies doing these schemes behind the scenes, and we never know, and they get caught and prosecuted and sent to prison. Travis Reinking is a person with delusions of grandeur. He thinks he's smarter than you. He believes he knows better than you. And so that he created a plan that still led to him getting caught does not absolve him of responsibility. He was very clear that it was his plan to go to the Waffle House. Very clear that it was his plan to kill as many people there. Very clear that it was his plan to get into his trunk and leave. Very clear that he was going to go to another Waffle House and kill some more people. That was his plan. Very clear that he was going to commit mass murder. Self-defense. Against who? What you heard was that the only issue he may have even possibly had with people at Waffle House happened over some hash browns in Caryville, Tennessee, at some point, who knows when before. And yet, Joe Perez didn't work at the Waffle House. See, now, if you were to tell me that Travis Reinking walked past Joe Perez, walked around the corner, and killed some people, I would still have an immense problem with that. I might still be standing here, but I'd have a little less solid of an argument. That's not what he did. He killed Joe first. Killed him. Then after he killed Torian, he walked in and never went to the area where the Waffle House employees were. He didn't go left. He went right. That was his choice. There's no question that D'Ebony Groves and Sharita Henderson were not Waffle House employees as they cowered, hoping that they could play dead underneath that table. No doubt. And yet, he killed them anyways. What did Sharita say? She tried to play dead, and then she opened her eyes. And in a moment, she looked at him. how terrifying it must have been. How frightening it must have been to see this man standing over her, that big gun that already killed people. And then he looked her dead in the eye and shot her. Not once, 3 times. This is a man who is evil. He knew what he was doing. He knew it was evil. And yet he comes to you and tells you he didn't know it was wrong. We have no burden to prove when it comes to the insanity defense. None. Defense says we should give you a motive. We don't have to give you a motive. We didn't have to put on any evidence, especially after the testimony of those doctors. We did put on some evidence because we've taken this case as serious as possible, because that's what it demands. The reality is, Travis Reinking decided that he wanted to punish people because his life was miserable. And misery loves company. So that's what he brought. Misery and despair on that day. The reason that he wanted to exact that misery is because he had decided that his life had been so unfulfilling, unhappy. He wanted to make a change, move out west to Colorado, walk around and see the beautiful vistas, hang out with some friends, some actual friends. He said, enjoy the finer things in life. To me, nothing was better than doing a couple puffs of marijuana out at Glass Pipe or Loud and going for a long walk down the bike trail in Salida. That was my happy place, in the mountain air, surrounded by an incredible view of nature and feeling like you're witnessing it for the very first time in life. It was glorious. It's a dream. It's really what he wants. His life is not going well here. He doesn't like his job. He doesn't have any friends. He doesn't like himself. He's concerned that maybe he's struggling with his sexuality, struggling with whether or not he's even a man or transsexual. And that makes him angry and agitated. And he acts out. He decided, I'm going to act out. I'm going to take a BMW, change my life. I'm going to go out there. What does he say? I'm going to take this BMW and I'm going to live a good life. So he's going to buy houses, repossessing is his term. We know that's his term for theft, for stealing, carjacking. He's going to live this great life out there, driving in nearly $100,000 car. And of course, because see, he thinks he's smarter than he is, that he's smarter than you, smarter than these doctors, and maybe he outsmarted them in this particular instance. Because he thinks he's smarter than you, he thought that he was going to get away with it. It isn't because of the mental illness, it's because the man thinks that he's got delusions of grandeur. I mean, this is somebody who thinks that Taylor Swift and Ariana Grande are so interested in him. Not that they just want to have sex with him, but that they would want to rape him. Yeah, whatever. He's got a mental illness, but the mental illness is not the reason he did this. He wanted to go out there and change his life. And so when he came back home that night, came back home from picking up his old truck that he obviously parked somewhere surreptitiously such that the police couldn't find it by the BMW dealership. When he got home and saw the police out there, he started to get angry. First thing he said was, he's tried to sneak into his apartment. Made sure he had his gun, just in case he needed to kill a couple of cops, I guess. Snuck into his apartment, went upstairs, tells the doctors that he went up there and went to sleep, but was worried maybe somebody might want to come talk to him. What he writes is that he has a rifle trained on them outside, as they're outside doing their job. Thankfully, former officer Caleb Andrews didn't go knock on his door. Wouldn't have been able to be here to testify. He said that over the next couple of days, he got angrier, yelled, screamed, mad. And so by the time we get to April 22nd, he's already well into formulating and carrying out his plan. Well into it. In reality, the plan started well before the BMW. April the 8th, he goes and gets 2 extra magazines. What do you need with 2 extra magazines? You've already got 1 magazine that carries 30 rounds. Why do you need 60 more at your ready? It's part of his plan. April 10th, he goes to get the silver bars. $1,700 worth of silver bars. Why? So he can make easy exchange without having to use a credit card or having to use a check. He can walk into one of those coin and currency somewhere, lay down one of those silver bars, and get cash money from it. So he had cash money in his wallet, $400 and something. So he's making a plan. The BMW was part of the plan. He picks up the silver bars on the 20th. He's ready to go. He's got his go bag. He's got his water. He's got his pistol. He's got his silver now. And so now it's time to make a run somewhere else. But the car is taken. She learned. That was a testimony. And he got upset. And so he drove to that Waffle House, angry, because he wanted to exact the same kind of pain and suffering that he felt on others. And if nothing else, anybody who wants to inflict pain and suffering, they know they are wrong. Plain and simple. I asked Dr. Wood, does he know what the term punishment means? Yes. He understands that punishment means to inflict suffering in retaliation. Yes. If you're acting in retaliation, then you understand that it is wrong. Yes. That was Dr. Wood's testimony. That means he knew he was wrong. Dr. Isom, General Norman asked, if he knew he was acting in retaliation, then that means he knew he was wrong. Yes. So then he has an appreciation for his wrongfulness. Absolutely has an appreciation for his wrongfulness. These expert witnesses are not the final deciders in this case. You are. You can reject it altogether. Just throw it out. Act as if they didn't even come in here and testify. Honestly, that's what the rules say. You could accept some parts. Say, well, I believe he's got a mental illness. I saw the video. He's got a mental illness. But the rest of it, you don't have to take any of that. Throw it out. Based on their inability, unwillingness to do a meticulous and careful evaluation such that these victims deserved. I want you to recall that in Dr. Isom's testimony, one of the things she didn't quite want to acknowledge is that she reviewed a journal in which he said he was writing a book in a way such that whoever read it would question his sanity. And he said that he wanted to get the book published before he started killing police officers, so that if they killed him, he would be a martyr. This is a man who is planning murder. He wants to carry out murder. You will read in his journal how he describes committing the murder, how he talks about it isn't how I thought it was going to be. Talks about how the blood was spraying in a way that he didn't expect or anticipate. Talks about how his skin was tingling. This is a man who knows right from wrong, completely and utterly understands it. Defense talked about the fact that a BMW sales lady said that he, in her brief interaction, may have reminded her of a friend. Well, you heard the testimony of several police officers, all of them who have been actually trained, not someone who has had an experience with one friend, trained experiences. They know how to interact with individuals who are experiencing symptoms of schizophrenia and know who they're supposed to call, know how they act. To a person, they testified that didn't happen with Travis Reinking. Not at all. Not one bit. These are the people who were interacting with him 34 hours after the shooting. Not one woman who had one experience with one friend. But they didn't want to highlight the fact that she said also in her testimony that he had moments of clarity. He was very clear. I'm taking this car. It's coming with me. He was very clear that if she didn't get out of that car, she too was coming with him. Thankfully, she did. Otherwise, who knows what could have happened? Maybe that baby bump she was rubbing in her testimony might not be with her. Defense said that choices are based on perception. What about Joe Perez Jr. could have forced him to perceive him in any way as a threat to him? He didn't describe Joe Perez Jr. as an alien, as someone else in the alien army. That's not what he says. He called him a target. Why did he call him a target? Well, it wasn't just to dehumanize him. It's because he read or watched a video online in which he said the military say the easiest way to make it easier to kill people, it's not call them people, call them targets. That's understanding wrongfulness, right? If you're able to say, I'm going to kill somebody, but in order to make it easier for me to do it, I have to rob them not only of their life, but their humanity in the process. You understand that what you are doing is wrong. He knew it was wrong. You'll read his journal. He says that after he kills Joe and Torian, as you see in the video, he casually steps over Joe's body as he's laying there on the ground. Says, well, gone this far. Might as well keep going. Keep killing people. That's somebody who understands that it is wrong. And that's the only standard that you have in here that you really need to consider, right? Is it clear and convincing that he didn't know what he was doing was wrong? Of course he did. Both the doctors essentially said it. They didn't want to completely walk back their testimony because they signed a report and didn't want to come across as unprofessional, I guess. But in reality, that was their testimony. He knew it was wrong. Defense said they have sympathy for the victims. I suppose words are an expression of sympathy, perhaps. But I can't tell that Travis Reinking has any sympathy for these people. How did he recreate it? He created these drawings on a styrofoam plates a year later. He's drawing them as stick figures, targets again. He's dehumanizing them again. He's showing that he's killed them, which means he has an absolute appreciation of the nature of his conduct, and he's taking away their humanity, knowing that he killed people, which I submit to you is also an appreciation of his wrongfulness. Travis Reinking had a plan. He absolutely had a plan. And it was clear from the moment he walked into that, the moment he walked out of his apartment. See, there was a question as to why he might have a jacket on while he was naked. We already discussed why he was naked. Distracts. Why do you have a jacket? Well, if he's naked, he can't carry extra rounds. He needs pockets. See, that's part of his plan. But see, as he sat there with these 90 rounds, he had to fill them up. He had to fill it up. Joe Perez Jr. Torian Sunderland. Aquila da Silva. Shantia Wagner. D'Ebony Groves. Sharita Henderson. James Shaw Jr. Well, he may have had another one for James Shaw Jr. That was his plan. There's a famous boxer, Mike Tyson, you know him. Probably heard the phrase. Every man has a plan until he gets punched in the mouth. He wasn't ready for him. He didn't know who was behind that door. He expected that when he went behind that bathroom door, he was going to have nothing but fish in a barrel, target practice, killing them. And behind that door was a man who was waiting to punch him in the mouth and disarm him and move him out of the way and get him out of that Waffle House and stop him from committing more murders at that Waffle House and the next Waffle House. That's what changed things. That's why he fled. He didn't flee because he wanted to. He fled because James Shaw moved him out the way. He pushed him out of there. He didn't think about that. And so as he went back to his apartment, which curiously was left unlocked, how else did he get in there, right? He took a shower. You saw James Shaw, he had blood on his hand, blood got on the gun, blood from his arms. What was he washing off? The blood. What's he do? He puts clothes on. He's no longer the naked man, now he's got clothes on. He puts his clothes on, he grabs his go bag, and he gets out of there. When? Dr. Eisen, when he heard the sirens, the police sirens that were coming for him in appreciation of wrongfulness. When did he get out there? According to Dr. Wood, when he heard the sirens because they were coming for him in appreciation for wrongfulness. And what did he do? He hid for 34 hours. According to him, he hid underneath a house until some dog came sniffing around and heard and maybe thought he might get found. And according to him, he wanted to go hotwire a car and steal it to assist in his flee, his departure, his escape from justice. It didn't work out. Eventually he does get seen hiding out in the thick brush of the woods out there in an undeveloped portion of Antioch. And an officer walks up on him, and according to him, the first thing that he does, he finds some cover, Travis Reinking. He gives it some thought. He reaches, like he's gonna reach for his gun. The gun is now in the backpack. It's just spent a day and a half underneath a house. Kind of hard to lay there with the gun on your hip. So it's not there anymore. He thinks about shooting that officer. Then he realizes, I'm caught. Nothing I can do. And he submits. He's making an assessment about the value of his life, one that he didn't make about the value of the lives of these wonderful young people who were killed. And he continues to submit to these officers. Never once. You saw the officer Corman. She might not have been much taller than this, right? And she told you he was half a body taller than him. You've seen this man stand up. Look at these big guards in here. These are big, strong men. He's bigger than them. He didn't try to flee out of here, did he? Not once. She didn't see that. He didn't try to run from that cop as she gracefully guided him with one arm, because that's all that she had to do, right? He didn't try to run from, he didn't try to fight with the nurse as she forces a catheter up his urethra. Nothing. One of the corporals says, I was around him twice a week. Twice a week. Never an issue. This is a man who now claims that these doctors now claim he's got this grand conspiracy, that he's afraid of the state. But when the guys with the guns who are actual state agents come for him, nothing but compliance. Nothing. That's because he understands wrongfulness. He knew what he was doing. He knew that it was wrong. He knew when to act in a way where he needed to be compliant, and he knew when he could act in a way where he could just be the murderous man that he wanted to be. Ladies and gentlemen of this jury, as I mentioned to you earlier, you took an oath to be fair, to be just, to consider the facts of this case, to do what's right. The evidence in this case is clear. He committed the murders. It certainly isn't clear that he didn't appreciate the wrongfulness when he committed the murders. So if you're going to do what's right based on the evidence that was in this case, the only right verdict, the only just verdict is guilty. Any other verdict would be as wrong as Travis Reinking was on April 22nd, 2018.
All right, Mr. Jury, that concludes the closing arguments of the attorneys. I'm now required by law to read to you in open court the jury charge, which contains all the law that applies to this particular case. Staff is about ready to hand you a copy of that jury charge. It's 44 pages long. Simply ask that you follow along with my reading of it rather than, obviously you can read it to yourself much more quickly than I can. Reading of it. And we'll get through it as quick as we reasonably can. Everybody got a copy? In the criminal court for Davidson County, Tennessee, Division 6, State of Tennessee versus Travis J. Reinking, case 2019-A-55, jury charge members of the jury. The defendant, Travis J. Reinking, is charged in counts 1 through 4 of the indictment with the crime of premeditated first-degree murder. These offenses necessarily include the lesser offenses of second-degree murder and voluntary manslaughter. The defendant is charged in counts 5 and 7 of the indictment with attempt to commit premeditated first-degree murder with serious bodily injury. These offenses necessarily include the lesser offenses of attempt to commit premeditated first-degree murder, attempt to commit second-degree murder, and attempt to commit voluntary manslaughter. The defendant is charged in counts 9 and 11 with attempt to commit premeditated first-degree murder. These offenses necessarily include the lesser offenses of attempt to commit second-degree murder and attempt to commit voluntary manslaughter. The defendant is charged in counts 6, 8, 10, and 12 of the indictment with employment of a firearm during the commission of or attempt to commit a dangerous felony. The defendant is charged in counts 13 through 16 with first-degree felony murder. These offenses necessarily include the lesser offense of second-degree murder. Travis J. Reinking pleads not guilty by reason of insanity to each and every offense embraced in this indictment. The evidence in this case has been completed. It's my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it's your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. The indictment in this case is a formal written accusation charging Travis J. Reinking with these crimes. It is not evidence against the defendant and does not create any inference of guilt. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, or any other remarks which I have made, do I mean to indicate any opinion as to the facts or what your verdict should be. Opening statements, closing arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. The statements were made by an attorney that you believe are not supported by the evidence. You should disregard them. This principle also applies to the alleged statements or alleged facts suggested by an attorney in a question presented to a witness. Therefore, an alleged statement or alleged fact suggested in the question is not evidence and should be disregarded unless the witness agreed with the statement or fact suggested in the question. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts and decide in this case. You should consider all of the evidence in light of your own observations and experiences in life. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless from all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence except on the issue of insanity as set forth later in these instructions. Reasonable doubt is that doubt created by an investigation of all the proof in the case and the inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every proposition, every element of proof necessary to constitute the offense. The state must have proven beyond a reasonable doubt all of the elements of the crimes charged, and that they were committed before the finding and returning of the indictment in this case. The burden is upon the state to prove by a preponderance of the evidence that these offenses were committed in Davidson County, Tennessee. by a preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. If you find the state has failed to prove by a preponderance of the evidence that these offenses were commenced or consummated in Davidson County, Tennessee, then you must return a verdict of not guilty. As previously stated, Travis J. Reinking is charged in counts 1 and 4 of the indictment with the crime of premeditated first-degree murder, and counts 5 and 7 with attempt to commit first-degree murder with serious bodily injury, and counts 9 and 11 with attempt to commit first-degree murder, and counts 6, 8, 10, and 12 with employing a firearm during the commission of or attempt to commit a dangerous felony, and in counts 13 through 16 with felony first-degree murder. These offenses legally include the lesser offenses set forth herein. In reaching your verdict, you shall first consider the offenses charged in the indictment. If you unanimously find Travis J. Reinking guilty of the indicted offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You shall not proceed to consider any lesser included offense until you have made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you naturally have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all the offenses charged and included in that count, you shall return a verdict of not guilty and proceed to the next count. The crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charge must be stated in your verdict. Indicted in lesser included offenses, count 1, premeditated first-degree murder. Any person who commits the offense of premeditated first-degree murder is guilty of a crime. For you to find Travis J. Reinking guilty of this offense, they must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that he unlawfully killed Joe Rene Perez Jr., and 2, that he acted intentionally. The defendant acts intentionally when it is the defendant's conscious objective or desire to cause the death of another. And 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill is formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. If you find from the proof beyond a reasonable doubt that Travis J. Reinking is guilty of premeditated first-degree murder, you will so report, and your verdict in that event shall be we, the jury, find Travis J. Reinking guilty of premeditated first-degree murder. You shall then proceed to determine guilt or innocence to count 2 of the indictment, to wit, premeditated first-degree murder. On the other hand, if you have a reasonable doubt that Travis J. Reinking is guilty of premeditated first-degree murder, then your verdict must be not guilty as to this offense. You shall then proceed to determine guilt or innocence to the lesser included offense of second-degree murder. Lesser included offense, second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find Travis J. Reinking guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that he unlawfully killed Joe Rene Perez Jr., and 2, that he acted knowingly. Knowingly means that the defendant acts with an awareness that his conduct is reasonably certain to cause the death of another. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that it is the defendant's conscious objective or desire to cause the death of another. If you find from the proof beyond a reasonable doubt that Travis J. Reinking is guilty of second-degree murder, you will so report in your verdict, and that event shall be we, the jury, find Travis J. Reinking guilty of second-degree murder. You shall then proceed to determine guilt or innocence to count 2 of the indictment, to wit, first-degree murder. On the other hand, if you have a reasonable doubt that Travis J. Reinking is guilty of second-degree murder, then your verdict must be not guilty as to this offense. You shall then proceed to determine guilt or innocence to the lesser included offense of voluntary manslaughter. Lesser included offense, voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find Travis J. Reinking guilty of this offense, state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that he unlawfully killed Joe Rene Perez Jr., and 2, that he acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in a near rational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in a near rational manner. Intentionally and knowingly is used in the second essential element of voluntary manslaughter and defined the same as the terms previously have been defined for second-degree murder. You are to refer to those definitions in your deliberations of this offense. If you find from proof beyond a reasonable doubt that Travis J. Reinking is guilty of voluntary manslaughter, you will so reporting the verdict in that event shall be, we the jury find Travis J. Reinking guilty of voluntary manslaughter. On the other hand, if you have a reasonable doubt that Travis J. Reinking is guilty of voluntary manslaughter, then your verdict must be not guilty as to this offense. In either event, you shall then proceed to determine guilt or innocence to count 2 of the indictment, to wit, premeditated first-degree murder. Count 2, premeditated first-degree murder. The indicted offense of premeditated first-degree murder and count 2 of the indictment and all lesser included offenses of the indicted offense are the same as the indicted offense and all lesser included offenses of premeditated first-degree murder contained in count 1, with the only distinction being the alleged victim in count 2 is Taurine Charles Sanderman. The essential elements necessary to commit premeditated first-degree murder and the definition of key terms contained in the said elements are set forth in count 1. You're to refer to those essential elements, key terms, and definitions in your deliberation of this offense as it relates to the victim, Taurine Charles Sanderman. Further, your order consideration of the indicted and lesser included offenses of count 2 shall proceed in the same manner as set forth in count 1. After you reach a verdict in count 2, you shall then proceed to determine guilt or innocence to count 3 of the indictment, to wit, premeditated first-degree murder. Count 3, premeditated first-degree murder. The indicted offense of premeditated first-degree murder and count 3 of the indictment and all lesser included offenses of the indicted offense are the same as the indicted offense and all lesser included offenses of premeditated first-degree murder contained in count 1, with the only distinction being that the alleged victim in count 3 is Aquila Jamal da Silva. The essential elements necessary to commit premeditated first-degree murder and the definition of key terms contained in said elements are set forth in count 1. You're to refer to those essential elements, key terms, and definitions in your deliberation of this offense as it relates to the victim, Aquila Jamal da Silva. Further, your order of consideration of the indicted and lesser included offenses of count 3 shall proceed in the same manner as set forth in count 1. After you reach a verdict in count 3, you shall then proceed to determine guilt or innocence to count 4 of the indictment, to wit, premeditated first-degree murder. Count 4, premeditated first-degree murder. The indicted offense of premeditated first-degree murder and count 4 of the indictment and all lesser included offenses of the indicted offense are the same as the indicted offense and all lesser included offenses of premeditated murder contained in count 1, with the only distinction being the alleged victim is D'Ebony Lachey Groves. The essential elements necessary to commit premeditated first-degree murder and the definition of key terms contained in said elements are set forth in count 1. You're to refer to those essential elements, key terms, and definitions in your deliberation of this offense as it relates to the victim, D'Ebony Lachey Groves. Further, your order of consideration of the indicted and lesser included offenses of count 4 shall proceed in the same manner set forth in count 1. After you reach a verdict in count 4, you shall then proceed to determine guilt or innocence of count 5 of the indictment, to wit, attempt to commit premeditated murder with serious bodily injury. Count 5, attempt to commit premeditated first-degree murder with serious bodily injury. Any person who attempts to commit premeditated first-degree murder with serious bodily injury is guilty of a crime. For you to find Travis J. Reinking guilty of this offense, state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that he intended to commit premeditated first-degree murder, and 2, that he did some act intending to cause an essential element of first-degree murder to occur and believed the act would cause the element to occur without further action on his part, and 3, that Shantia Wagner suffered serious bodily injury. Intended or intending means that it is the defendant's conscious objective or desire to cause the death of another. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. The essential elements necessary to commit the offense of premeditated first-degree murder and the definition of key terms contained in said elements have been set forth previously in count 1. You refer to those essential elements, key terms, and definitions in your deliberation of this offense. If you find from the proof beyond a reasonable doubt that Travis J. Reinking is guilty of attempt to commit first-degree murder with serious bodily injury, you will so report, and your verdict in that event shall be, we the jury find Travis J. Reinking guilty of attempt to commit first-degree murder with serious bodily injury. You shall then proceed to determine guilt or innocence to count 6 of the indictment, to wit, unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony. On the other hand, if you have a reasonable doubt that Travis J. Reinking is guilty of attempt to commit first-degree murder with serious bodily injury, then your verdict must be not guilty as to this offense. You shall then proceed to determine guilt or innocence to the lesser included offense of attempt to commit premeditated first-degree murder. Lesser included offense, attempt to commit premeditated first-degree murder. Any person who attempts to commit premeditated first-degree murder is guilty of a crime. For you to find Travis J. Reinking guilty of this offense, state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that he intended to commit premeditated first-degree murder, and 2, that he did some act intending to cause an essential element of first-degree murder to occur, and at the time believed the act would cause the element to occur without further action on his part. Intended or intending means that it is the defendant's conscious objective or desire to commit premeditated first-degree murder. The essential elements necessary to commit the offense of premeditated first-degree murder and the definition of key terms contained in said elements have been set forth previously in count 1. You refer to those essential elements, key terms, and definitions in your deliberation of this offense. If you find from the proof beyond a reasonable doubt that Travis J. Reinking is guilty of attempt to commit premeditated first-degree murder, you will so report. We, the jury, find Travis J. Reinking guilty of attempt to commit premeditated first-degree murder. You shall then proceed to determine guilt or innocence on to count 6 of the indictment, to wit, unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony. On the other hand, if you have a reasonable doubt that Travis J. Reinking is guilty of attempt to commit first-degree murder, then your verdict must be not guilty as to this offense. You shall then proceed to determine guilt or innocence to the lesser included offense of attempt to commit second-degree murder. Lesser included offense, attempt to commit second-degree murder. Any person who attempts to commit second-degree murder is guilty of a crime. For you to find Travis J. Reinking guilty of this offense, state must have proven beyond a reasonable doubt the existence of the following elements. That he intended to commit the specific offense of second-degree murder, and 2, that he did some act intending to cause an essential element of second-degree murder to occur, and at the time he believed the act would cause the element to occur without further action on his part. Intended or intending means that it is the defendant's conscious objective or desire to commit second-degree murder. The essential elements necessary to commit the offense of second-degree murder and definition of key terms contained in said elements have been set forth previously in count 1. You refer to those essential elements, key terms, and definitions in your deliberation of this offense. If you find from the proof beyond a reasonable doubt that Travis J. Reinking is guilty of attempt to commit second-degree murder, you will so report in your verdict, and that event shall be, we, the jury, find Travis J. Reinking guilty of attempt to commit second-degree murder. You shall then proceed to determine guilt or innocence to count 6 of the indictment with unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony. On the other hand, if you have a reasonable doubt that Travis J. Reinking is guilty of attempt to commit second-degree murder, then your verdict must be not guilty as to this offense. You shall then proceed to determine guilt or innocence to the lesser included offense attempt to commit voluntary manslaughter. Lesser included offense attempt to commit voluntary manslaughter. Any person who attempts to commit voluntary manslaughter is guilty of a crime. For you to find Travis J. Reinking guilty of this offense, state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that he intended to commit the specific offense of voluntary manslaughter, and 2, that he did some act intending to cause an essential element of voluntary manslaughter to occur, and at the time believed the act would cause the element to occur without further action on his part. Intended or intending means it is the defendant's conscious objective desire to commit voluntary manslaughter. The essential elements necessary to commit the offense of voluntary manslaughter and definition of key terms contained in said elements have been set forth previously in count 1. You refer to those essential elements, key terms, and definitions in your deliberation of this offense. If you find from the proof beyond a reasonable doubt that Travis J. Reinking is guilty of attempt to commit voluntary manslaughter, you will so report. Any verdict in that event shall be, we the jury find Travis J. Reinking guilty of attempted voluntary manslaughter. On the other hand, if you have reasonable doubt that Travis J. Reinking is guilty of attempt to commit voluntary manslaughter, then your verdict must be not guilty as to this offense. In either event, you shall then proceed to determine guilt or innocence to count 6 of the indictment, to wit, unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony. Count 6, unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony. Any person who unlawfully employs a firearm during the commission of or attempt to commit a dangerous felony is guilty of a crime. For you to find Travis J. Reinking guilty of this offense, state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that he employed a firearm, and 2, that the employment was during the commission of a dangerous felony, to wit, attempt to commit premeditated first-degree murder of Chantia Wagner, and 3, that he acted intentionally. The essential elements necessary to commit the offense of attempt to commit premeditated first-degree murder, and the definition of key terms contained in said elements have been set forth previously in count 5 of these instructions. You refer to those essential elements, key terms, and definitions in your deliberations of this offense. Employ means to make use of. Firearm means any weapon designed, made, or adapted to expel a projectile by the action of an explosive, or any device readily convertible to that use. Intentionally means the defendant acts with a conscious objective or desire to engage in conduct. If you find from the proof beyond a reasonable doubt that Travis J. Reinking is guilty of unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony, you will so report in your verdict, and that event shall be. We, the jury, find Travis J. Reinking guilty of unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony. On the other hand, if you have a reasonable doubt that Travis J. Reinking is guilty of unlawful employment of a firearm during the commission of a dangerous felony, then your verdict must be not guilty as to this offense. In either event, you shall then proceed to determine guilt or innocence to count 7, to wit, attempt to commit premeditated first-degree murder with serious bodily injury. Count 7, attempt to commit premeditated first-degree murder with serious bodily injury. The indicted offense of attempt to commit premeditated first-degree murder with serious bodily injury, count 7 of the indictment and all lesser included offenses of the indicted offense are the same as the indicted offense and all lesser included offenses of attempt to commit premeditated first-degree murder with serious bodily injury contained in count 5, with the only distinction being that the alleged victim in count 7 is Sharita Henderson. The elements necessary to commit attempt to commit premeditated first-degree murder with serious bodily injury and the definition of key terms contained in these elements are set forth in count 5. Here refer to those essential elements, key terms, and definitions in your deliberation of this offense as it relates to the victim, Sharita Henderson. Further, your order of consideration of the indicted and lesser included offenses of count 7 shall proceed in the same manner as set forth in count 5. After you have reached a verdict in count 7, you shall then proceed to determine guilt or innocence to count 8 of the indictment, to wit, unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony. Count 8, unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony. The indicted offense of unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony in count 8 are the same as the indicted offense of unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony contained in count 6, with the only distinction being that the alleged victim is Sharita Henderson. The elements necessary to commit unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony and the definition of key terms contained in said elements are set forth in count 6. You refer to those essential elements, key terms, and definitions in your deliberation of this offense as it relates to Sharita Henderson. After you reach a verdict in count 8, you shall then proceed to determine guilt or innocence in count 9 of the indictment, to wit, attempt to commit premeditated first-degree murder. Count 9, attempt to commit premeditated first-degree murder. The indicted offense of attempt to commit premeditated first-degree murder in count 9 and all lesser included offenses of the indicted offense are the same as the indicted offense and all lesser included offenses of attempt to commit premeditated first-degree murder contained in count 5, with the only distinction being that the alleged victim is Kayla Shaw. The elements necessary to attempt to commit premeditated first-degree murder and definition of key terms contained in said elements are set forth in count 5. You refer to those essential elements, key terms, and definitions in the deliberation of this offense. Further, your order of consideration of the indicted and lesser included offenses of count 9 shall proceed in the manner set forth in count 5. After you reach a verdict in count 9, you shall then proceed to determine guilt or innocence to count 10 of the indictment, to wit, unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony. Unlawful count 10, unlawful employment of firearm during the commission of or attempt to commit a dangerous felony. The indicted offense of unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony in count 10 of the indictment, the same as the indicted offense of unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony contained in count 6. The only distinction being that the alleged victim is Kayla Shaw. The elements necessary to commit unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony and definition of key terms contained in said elements are set forth in count 6. Here refer to those central elements, key terms, and definitions in your deliberation of this offense is released to Kayla Shaw. Further, your order of consideration of the indicted and lesser included offense shall proceed in the same manner set forth in count 6. After you reach a verdict in count 10, you shall then proceed to determine guilt or innocence to count 11, the indictment to wit attempt to commit premeditated murder. Count 11, attempt to commit premeditated first-degree murder. The indicted offense of attempt to commit premeditated first-degree murder in count 11 of the indictment and all lesser included offenses of the indicted offense were same as the offense of indicted offense and all lesser included offense of attempt to commit premeditated first-degree murder contained in count 5. The only distinction being that the alleged victim is James E. Shaw, Jr. The elements necessary to commit attempt to commit premeditated first-degree murder, the definition of key terms contained in said elements are set forth in count 5. You refer to those essential elements, key terms, and definitions in your deliberation of this offense as it relates to James E. Shaw, Jr. Further, your order of consideration of the indicted and lesser included offense of count 11 shall proceed in the same manner set forth in count 5. After you have reached a verdict in count 11, you shall then proceed to determine guilt or innocence to count 12 of the indictment to wit unlawful employment of a firearm during the commission of or attempt to commit first-degree murder. Count 12, unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony. The indicted offense of unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony in count 12 of the indictment and all lesser included offenses of the indicted offense are the same as the indicted offense of unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony contained in count 6, with the only distinction being that the alleged victim is James E. Shaw, Jr. The elements necessary to commit unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony and definition of key terms contained in said elements are set forth in count 6. You refer to those central elements, key terms, and definitions in your deliberation of this offense. Further, your order of consideration of indicted and lesser included offenses shall proceed in the same manner set forth in count 6. After you reach a verdict in count 12, you shall then proceed to determine guilt or innocence to count 13 of the indictment to wit first-degree felony murder. Count 13, first-degree felony murder. Any person who commits first-degree felony murder is guilty of a crime. For you find that Travis J. Reinking guilty of this offense, they must have proven beyond a reasonable doubt the existence of the following elements. 1, that he unlawfully killed Joe Rene Perez Jr., and 2, that the killing was committed in the perpetration of the attempt to perpetrate premeditated first-degree murder. That is, that the killing was closely connected to the alleged premeditated first-degree murder and was not a separate, distinct, and independent event. And 2, that the defendant intended to commit the alleged premeditated first-degree murder. The elements necessary to commit premeditated first-degree murder and the definition of key terms contained in said elements are set forth in count 1. You refer to those essential elements, key terms, and definitions in your deliberation of this offense. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by you after consideration of all the facts and circumstances in the case. Killing may proceed, coincide with, or follow the premeditated first-degree murder and still be considered as occurring in the perpetration of the premeditated first-degree murder so long as there is a connection in time, place, and continuity of action. Intentionally is used in third essential element. First-degree felony murder is defined the same as the term previously has been defined in count 1. You refer to that definition in your deliberation of this offense. If you find from the proof beyond a reasonable doubt that Travis J. Reinking is guilty of first-degree felony murder, you will so report any verdict in that event shall be, we the jury find Travis J. Reinking guilty of first-degree felony murder. You shall then proceed to determine guilt or innocence to count 14 of the indictment to wit first-degree felony murder. On the other hand, if you have a reasonable doubt that Travis J. Reinking is guilty of first-degree felony murder, then your verdict must be not guilty as to this offense. You shall then proceed to determine guilt or innocence to the lesser included offense of second-degree murder. Lesser included offense, second-degree murder. Any person who commits the offense of second-degree murder is guilty of a crime. For you to find Travis J. Reinking guilty of second-degree murder, the state must have proven beyond a reasonable doubt the same essential elements as are contained in the lesser included offense of second-degree murder contained in count 1. You would refer those essential elements, key terms, and definitions in your deliberation of this offense. If you find from the proof beyond a reasonable doubt that Travis J. Reinking is guilty of second-degree murder, you will so report your verdict, and that man shall be. We, the jury, find Travis J. Reinking guilty of second-degree murder. On the other hand, if you have a reasonable doubt that Travis J. Reinking is guilty of second-degree murder, then your verdict must be not guilty as to this offense. In either event, you shall then proceed to determine guilt or innocence to count 14 of the indictment. Count 14, first-degree felony murder. The indicted offense of first-degree felony murder and count 14 of the indictment and all lesser included offense of the indicted offense is the same as the indicted offense and lesser included offense of first-degree felony murder contained in count 13, with the only distinction being that the alleged victim is Taurine Charles Sanderson. The elements necessary to commit first-degree felony murder and the definition of key terms contained in said elements are set forth in count 13. It'll refer to those essential elements, key terms, and definitions in your deliberation of this offense as it relates to Taurine Charles Sanderson. Further, your consideration of the indicted offense and lesser included offense in count 14 shall proceed in the same manner as set forth in count 13. After you have reached a verdict in count 14, you shall then proceed to determine guilt or innocence to count 15 of the indictment with first-degree felony murder. Count 15, first-degree felony murder. The indicted offense of first-degree felony murder in count 15 of the indictment and all lesser included offense of the indicted offense are the same as the indicted offense and lesser included offense of first-degree felony murder contained in count 13, with the only distinction being that the alleged victim is Aquila Jamal da Silva. The elements necessary to commit any first-degree felony murder and the definition of key terms and set elements are set forth in count 13. You refer those essential elements, key terms, and definitions in your deliberation of this offense as it relates to Aquila Jamal da Silva. Further, your order of consideration of the indicted offense and lesser included offense of count 15 shall proceed in the same manner as set forth in count 13. After you have reached a verdict on count 15, you shall then proceed to determine guilt or innocence on count 16 of the indictment to wit first-degree felony murder. Count 16, first-degree felony murder. The indicted offense of first-degree felony murder and count 16 of the indictment, the lesser included offense of the indicted offense are the same as the indicted offense and lesser included offense of first-degree felony murder contained in count 13. With the only distinction being that the alleged victim is D'Ebony Lachey Groves. The elements necessary to commit any first-degree felony murder and the definition of key terms contained in said elements are set forth in count 13. Refer to those essential elements, key terms, and definitions in your deliberation of this offense as it relates to D'Ebony Lachey Groves. Further, your order of consideration of the indicted offense and the lesser included offense of count 16 shall proceed in the same manner as set forth in count 13. Defense insanity. Travis J. Reinking has raised the defense that he was insane at the time of the commission of the offenses and therefore is not guilty by reason of insanity. However, you are to consider this affirmative defense if and only if you have first found Mr. Reinking guilty of one or more of the offenses contained in the indictment. A person is not responsible for criminal conduct if, at the time of the commission of the acts constituting the offense, the person as a result of a severe mental disease or defect was unable to appreciate the nature of the conduct or the wrongfulness of such person's acts. A mental disease or defect by itself is not a defense. The term mental disease or defect does not include any abnormality manifested only by repeated criminal or otherwise antisocial behavior. The defendant has the burden of proving the defense of insanity. For you to return a verdict not guilty by reason of insanity, the defendant must prove both the following elements by clear and convincing evidence. 1, he had a severe mental disease or defect at the time the acts constituting the crime were committed. And 2, that as a result of this severe mental disease or defect, he was not able to understand the nature of what he was doing or to understand that what he was doing was wrong. The law does not distinguish between legal and moral wrong. It is sufficient to defend his actions to be wrong in some form or another. Clear and convincing evidence means evidence in which there is no serious or substantial doubt about the correctness of the conclusions drawn from the evidence. Lay witnesses testified with respect to their observation of defendant's appearance, behavior, speech, and actions. Such persons are permitted to testify as to their own observations and other facts known to them. Lay witnesses may express an opinion based on those observations and facts known to them. In weighing the testimony of such lay witnesses, you may consider The circumstances in which the witness at the time of the was encountered, the circumstances of each witness at the time the defendant was encountered, his or her opportunity to observe the defendant and to know the facts to which he or she has testified, his or her willingness and capacity to expound freely as to his or her observations and knowledge, the basis of his or her opinion and conclusions, the nearness or remoteness of his or her observations of the defendant in point of time to the commission of the offense charged. He may also consider whether the witness observed extraordinary or bizarre acts performed by the defendant. In evaluating such testimony, you should take into account the extent of the witness's observations of the defendant and the nature and length of time of the witness's contact with the defendant. You should bear in mind that an untrained person may not be able to readily detect a mental disease or defect. Also, the failure of a lay witness to observe abnormal acts by the defendant may be significant only if the witness had prolonged intimate contact with the defendant. Whether the defendant was insane is defined in these instructions is a question for you alone to decide. In determining the defendant's mental status at the time of the alleged crime, you are entitled to look to the evidence of his actions and words before, at, and immediately after the commission of the alleged crime. If you find the defendant not guilty by reason of insanity, the form of your verdict shall be, we find the defendant not guilty by reason of insanity. A verdict of not guilty by reason of insanity shall result in the automatic detention of the defendant pending further medical and legal findings with a psychological evaluation to be completed within 30 days. General instructions, evidence, and guides for its consideration. One type of evidence is called direct evidence, and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which gives you about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. In fact, it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. It is your duty to decide how much weight to give direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one or say that one is better evidence than the other. You should consider all the evidence, both direct and circumstantial, and give it whatever weight you believe it deserves. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile them if you can, without hastily or rashly concluding that any witness is sworn falsely, for the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof if any of his or her general character, the evidence if any of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any, are shown, and all the evidence in the case tending to corroborate or to contradict him or her. Sometimes the testimony of different witnesses will not agree. You must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. You hear things differently, and witnesses may testify honestly but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance with his or her evidence on the witness stand. Proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility, not as substantive evidence of the truth of the matter asserted in such statements. Further, the witness may be impeached by careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When the witness is thus impeached, you have the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. In this case, the parties have submitted certain stipulations for your consideration. A stipulation is an agreement by the parties that the facts stipulated to you are in fact true and not subject to dispute. However, you're not required to accept these stipulations. As with all other evidence, you, as the sole judge of the facts in this case, will give these stipulations such weight and effect as you deem proper, along with all the other evidence in the case. Flight. The flight of a person accused of a crime is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt that the defendant pled is a question for your determination. The law makes no precise distinction as to the manner or method of flight. It may be open, or it may be hurried or concealed departure. It may be a concealment within the jurisdiction. However, it takes both a leaving the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community, or a leaving of the community for parts unknown to constitute flight. If flight is proved, the fact of flight alone does not allow you to find that the defendant is guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact of flight, if flight is so proven, together with all the other evidence when you decide the guilt or innocence of the defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by the facts and circumstances of the case. Whether there was flight by the defendant, the reason for it, and the way to be given to it are questions for you to determine. During the trial, you heard the expert testimony of Ms. Julie Ellis, who was described as an expert in forensic DNA analysis, Ms. Bridget Chambers, who was described as an expert in forensic firearms and tool mark identification and analysis, Dr. Thomas Deering, who was described as an expert in forensic pathology, and Dr. Mary Elizabeth Wood and Rena Eisen, who were described as experts in forensic psychology. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist you in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it's up to you to decide whether you believe his testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness' background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions are based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Additionally, you may have heard one or more of the forensic psychologists testify the information that they relied upon in offering their expert opinion. This information, while admitted, is generally hearsay and is intended solely for your use to understand, weigh, and assess the expert opinion given. The information may not be used as substantive evidence to prove the truth of the underlying hearsay facts relied upon by the expert witness, unless the underlying facts were observed by the expert witness or were statements made by the defendant, but not including the YouTube video. The YouTube video may only be considered by you to weigh and assess the opinions given by the expert forensic psychologist, along with all the other evidence available to the experts in making their opinions. The testimony of Gina Jacobson was tendered to you by video deposition because she was unavailable to attend the trial in person. Nevertheless, her testimony was given under oath and is subjected to the same rules of direct and cross-examination as if she had testified in person. You're to evaluate her testimony and weigh her credibility the same as you do every other witness who testified during the trial of this case. Travis J. Reinking has not taken the stand to testify as a witness, but you shall place no significance on this fact. He is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take a stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Concluding instructions. You can have no prejudice or sympathy or allow anything but the law and the evidence to influence your verdict. You must render your verdict with absolute impartiality as you think the law and the evidence require. The verdict must represent the judgment of all 12 jurors. It must be unanimous. As jurors, it is your duty to consult with one another and to deliberate with a view to reaching an agreement if you can do so without surrendering your individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with the other jurors. During your deliberations, do not hesitate to examine your views and change your opinion, but do not surrender your conviction as to the weight or effect of the evidence solely because of the opinion of other jurors or for the mere purpose of returning a verdict. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, or computer, the internet, any internet service or any text or instant messaging service or any internet chat room, blog, or website, including but not limited to Facebook, Instagram, LinkedIn, YouTube, Snapchat, or Twitter, to communicate to anyone any information about this case or to conduct any research about this case until you have returned your verdict and the trial has concluded. Members of the jury, I notice that many of you appear to be taking notes during the trial of this case. Please bear in mind that these are your notes and for your use alone. The taking of notes is simply an aid to memory, and any juror who takes notes will use those notes only for his or her own benefit in that regard, and not as an authoritative thing to show other jurors. Notes are to be used only to refresh your personal memory and not to replace it, nor are they to persuade the opinion of any other juror. If you find the state has proven each element of offense beyond a reasonable doubt, then you should find the defendant guilty of that offense. In that event, your four-person report, you find the defendant guilty. On the other hand, if you find the state has not proven each element of offense beyond a reasonable doubt, or if you have a reasonable doubt as to the defendant's guilt, then you must find the defendant not guilty of that offense. In that event, your four-person report, you find the defendant not guilty. If you find the defendant guilty of one or more counts of first-degree murder, you will set his punishment of life with or without parole at a hearing to be conducted immediately following your verdict of first-degree murder. If you find the defendant guilty of any other offense, it will be my responsibility to determine the sentence and to set the fine, if any, in a separate sentencing hearing. When you retire to the jury room, you will first select a foreperson who will preside over your deliberations. When you have reached a verdict, you will return to this courtroom and your foreperson will announce your verdict on the verdict form to be provided. You will be provided with forms for all possible verdicts in this case. The foreperson will complete and sign the appropriate verdict form. The verdict form which you'll receive, and consisting of, I don't think it's 14 pages, I think it's 11, but which you'll receive and consisting of 11 pages reads as follows. In the criminal court for Davidson County, Tennessee, Division 6, State of Tennessee versus Travis Reinking, case number 2019-A-55, jury verdict form. Count 1, we the jury naturally find Travis J. Reinking for the offense of first-degree premeditated murder, guilty, not guilty, not guilty by reason of insanity. Second-degree murder, guilty, not guilty, not guilty by reason of insanity. Voluntary manslaughter, guilty, not guilty, not guilty by reason of insanity. A place for the foreperson to sign. Count 2, we the jury naturally find Travis J. Reinking for the offense of premeditated first-degree murder, guilty, not guilty, not guilty by reason of insanity. Second-degree murder, guilty, not guilty, not guilty by reason of insanity. Voluntary manslaughter, guilty, not guilty, not guilty by reason of insanity. A place for the foreperson to sign. Count 3, we the jury naturally find Travis J. Reinking for the offense of premeditated first-degree murder, guilty, not guilty, not guilty by reason of insanity. Second-degree murder, guilty, not guilty, not guilty by reason of insanity. Voluntary manslaughter, guilty, not guilty, not guilty by reason of insanity. And a place for the foreperson to sign. Count 4, we the jury naturally find Travis J. Reinking for the offense of premeditated first-degree murder, guilty, not guilty, not guilty by reason of insanity. Second-degree murder, guilty, not guilty, not guilty by reason of insanity. Voluntary manslaughter, guilty, not not guilty, not guilty by reason of insanity, a place for the foreperson to sign. Count 5, we, the jury, naturally find Travis J. Reinking for the offense of attempt to commit premeditated first-degree murder with serious bodily injury. Guilty, not guilty, not guilty by reason of insanity, attempt to commit premeditated first-degree murder. Guilty, not guilty by reason of insanity, attempt to commit second-degree murder. Guilty, not guilty by reason of insanity, attempt to commit voluntary manslaughter. Guilty, not guilty by reason of insanity, a place for the foreperson to sign. Count 6, we, the jury, naturally find Travis J. Reinking for the offense of unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony. Guilty, not guilty by reason of insanity, a place for the foreperson to sign. Count 7, we, the jury, naturally find Travis J. Reinking for the offense of attempt to commit premeditated first-degree murder with serious bodily injury. Guilty, not guilty by reason of insanity, attempt to commit first-degree murder. Guilty, not guilty by reason of insanity, attempt to commit second-degree murder. Guilty, not guilty by reason of insanity, attempt to commit voluntary manslaughter. Guilty, not guilty by reason of insanity. We, the jury, naturally find Travis J. Reinking for the offense of unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony. Guilty, not guilty by reason of insanity, a place for the foreperson to sign. Count 9, we, the jury, naturally find Travis J. Reinking for the offense of attempt to commit premeditated first-degree murder. Guilty, not guilty by reason of insanity, attempt to commit second-degree murder. Guilty, not guilty by reason of insanity, attempt to commit voluntary manslaughter. Guilty, not guilty by reason of insanity, a place for the foreperson to sign. Count 10, we, the jury, naturally find Travis J. Reinking for the offense of unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony. Guilty, not guilty by reason of insanity, a place for the foreperson to sign. Count 11, we, the jury, naturally find Travis J. Reinking for the offense of attempt to commit premeditated first-degree murder. Guilty, not guilty by reason of insanity, attempt to commit second-degree murder. Guilty, not guilty by reason of insanity, attempt to commit voluntary manslaughter. Guilty, not guilty by reason of insanity, in the place for the foreperson to sign. Count 12, we, the jury, naturally find Travis J. Reinking for the offense of unlawful employment of a firearm during the commission of or attempt to commit a dangerous felony. Guilty, not guilty by reason of insanity, a place for the foreperson to sign. Count 13, we, the jury, naturally find Travis J. Reinking for the offense of first-degree felony murder. Guilty, not guilty by reason of insanity, second-degree murder. Guilty, not guilty by reason of insanity, a place for the foreperson to sign. Count 14, we, the jury, naturally find Travis J. Reinking for the offense of first-degree felony murder. Guilty, not guilty by reason of insanity, second-degree murder. Guilty, not guilty by reason of insanity, a place for the foreperson to sign. Count 15, we, the jury, naturally find Travis J. Reinking for the offense of first-degree felony murder. Guilty, not guilty by reason of insanity, second-degree murder. Guilty, not guilty by reason of insanity, a place for the foreperson to sign. Count 16, we, the jury, naturally find Travis J. Reinking for the offense of first-degree felony murder. Guilty, not guilty by reason of insanity, second-degree murder. Guilty, not guilty by reason of insanity, a place for the foreperson to sign and the presiding judge to sign. The indictment, together with the exhibits and the verdict form, will be delivered to you. In a few minutes, you will retire to consider your verdict. First of all, about the exhibits, you're not allowed to take back the weapons and the ammunition and any items that may have some type of bodily fluids on it or this type of thing. If you want to see any of those, you will just let us know and we'll bring you back in the courtroom to allow you to do it. But for obvious reasons, we can't let guns and ammunition be flying around the courthouse. Also, during the course of your deliberations, the Faro scan that was utilized during the state's case in chief will not be sent back to you. In actuality, that was a massive amount of evidence that was produced, so they cut down and used part of what they want. If you want to see, and there's other things on that Faro scan, if you want to see anything about the Faro scan, you'll again need to come back into this courtroom and we'll address it that way. In reality, most of these exhibits aren't going to go back with you because they fall under one of those provisions as it relates to exhibits. Also, I don't know if I indicated this to you earlier in the week or not, but when it came time to begin your deliberations, 2 of you would be randomly selected as jurors in this case, be designated as alternate, and would be excused from further service on the trial of this particular case. We're going to do that at this point in time through our highly sophisticated lottery system. Juror number 51 in seat 14 and juror number 79 in seat 3 have been selected as the alternates in this case, and you will be excused from further service on this jury. Before you leave, well, we'll have to make arrangements to get back to the hotel and everything else. But before you leave, under any circumstance, and you're welcome to stay if you want while the deliberation is going on. You just won't be involved in you won't be in deliberation room. But certainly you're more than welcome to stay if you want to. But I personally want to come and give you my sincerest appreciation for the efforts and time you've put in over the last 2 weeks. I know jury service can be an inconvenience at any time, but under the circumstances of this case, there's been a lot more restrictions and inconveniences placed on you, and I want to sincerely express my appreciation, as well as that on behalf of the parties, because I can assure you they appreciate it as well. Also, I've been telling you, I don't know how many times over the last 2 weeks, to keep your mouth shut, don't talk to anybody, keep your thoughts to yourself, and now it comes time for everybody to go back there and express their opinions, and I've yanked you out of the of that process. So I'm gonna let you unload on me. You can say anything you want, talk about anything you want, I'll answer any questions you may have, whatever the case may be. But certainly I want to give you that opportunity to discuss anything about the trial of the case, from the process itself or anything else. So after I get these jurors out of here and they begin their deliberations and have their lunch, I'll meet with you in the conference room and we can sit and chit chat for a little while. Whoever is selected the forward person, you will be given the original verdict form, which is 11 pages, not 14. This is the verdict form that needs to be completed, not the one that is attached to your copy of the jury charge. And as I say, you need to sign. Can't reach a verdict unless it's unanimous. If you reach a unanimous verdict, then the foreperson needs to sign as to each count, not just one time. Also, during the course of your deliberations, if any one of you who are involved in the deliberations gets up and leaves the room for any reason whatsoever, your deliberations must cease. There's not to be any discussion of the trial of this case unless all 12 of you are in the deliberation room and in a position to either listen to what everybody else is saying or speak your own piece. So you can't break up in little groups and discuss the case or anything else. It's all 12 of you have to be engaged in the process equally. Is there anything else from the state? Anything from the defense? All right, if I can get my staff, raise their hand and get sworn.
Do you solemnly swear or affirm that you will take this jury committed to your charge, keep them separate and apart from all citizens, allow no one to speak to them or speak to them yourselves on the subject of the trial, except to ask if they have agreed as to their verdict? So you got it.
All right, if y'all will step on back, and juror number 79 and number 51, I'll be back to see you in just a few minutes, okay? Did you get it on? Do I need to go back and read it again?
Speed building class. You can get your job as an instructor.
Yeah, all right. That'll work. Y'all have anything? All right. For some reason, I just signed the jury.
The only time anything's been faster.
Yeah.
The only time anything's been faster is when I did the board of auctioneers.
Yeah, they can really go.
Oh my goodness.
I don't know how anybody keeps up with that. Okay.